Titles in Commerce, featuring NTT New Trust Technology. Presenting your host, Christian Walters. Muted.
Welcome, everyone, to this Monday, July 26, 2010 edition of Money Banking and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next. Take notice and acknowledgement with agreement that this show and/or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and/or guidance by a licensed attorney. This private show and/or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and/or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and/or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Again, thank you all for attending this Monday, July 26th edition of Money Banking and Trust and NTT. We've been going over Book 90 of Corpus Juris Secundum, and we left off on page 162 on Section 218, Proceedings, and we'll pick up there. Page 162, Section 218, Proceedings. In general, the nature of proceedings proper to employ for appointment of trustees is dependent on local practice and statutory provisions. Nature proper to employ for appointment of trustees is dependent on local practice and statutory provisions, and where not otherwise provided by statute, it would seem that jurisdiction to appoint trustees may be invoked either by bill or petition. It has been both affirmed and denied that a departure from the usual practice of the court renders the appointment void. The contention that the court did not act under the appropriate one of two statutes bearing on the proceeding cannot be sustained, where there was substantial compliance with the requirements of both statutes. In proceedings to remove a trustee and appoint a successor, it is not necessary for plaintiff to file the bond required by statute in suit to authorize the trustee to sell or otherwise deal with trust property. B. Jurisdiction and venue. The jurisdiction exercised by a court of equity in appointing a trustee is quasi in rem and may be based on jurisdiction of the parties or of the subject matter of the trust. The jurisdiction exercised by a court of equity in appointing a trustee is quasi in rem and may be based on jurisdiction of the parties or of the subject matter of the trust. The state or county where the trust property is located has jurisdiction to appoint a substitute or successor trustee. On the other hand, if proper parties are within the reach of the process of the court, it may appoint a trustee even though the trust property is located elsewhere. Although there is some authority holding the courts of one state cannot appoint a trustee of lands in another state in place of deceased trustee, the settler, nor can they appoint a trustee to sell such lands. Furthermore, it has been held that the fact that the settlor resided in the state and did so at the time the trust was created did not give a state court jurisdiction over the subject matter of the proceedings wherein the settlor sought appointment of the successor trustee. Where the corpus of the trust was in another state and the named trustee was in another state, the other's trust, the income of which constituted the res of the instant trust, were administered in the other state. In order to uphold service out of the state, in order to show cause why a successor trustee should not be appointed to administer a trust, it is necessary for the court to have jurisdiction of the corpus of the trust sought to be administered. Where the trustees and beneficiaries reside in different jurisdictions, the beneficiaries may be authorized to have a trustee appointed in the jurisdiction of their residence, and the courts of the original trustee's residence may direct him to transfer the property to the new trustee, although where the creator of the trust has indicated his desire that it would be administered in the state of his residence, the court of a different state may not appoint a successor trustee. Personal jurisdiction depends on the domicile of the interested persons at the time of the application rather than on their domicile when the trust was created. Jurisdiction over the parties may be acquired by personal or voluntary appearance. The court of original jurisdiction retains power to appoint a trustee in place of one who has left the state and died a non-resident. The court of a county in which a will has been probated is proper court to appoint a trustee created by the will, but this is only a rule of convenience, and a decree of another court is not void, and the courts of the state where the parties are domiciled may act, although the will was probated in another state. C. Application for appointment in general. In order that the court may act to appoint trustees, it has been held that the matter should be called to its attention by some interested party by proper proceedings instituted without undue delay. It has been held that the court cannot act to appoint trustees unless some interested party calls the matter to its attention by proper proceedings, although there is authority to the view that, irrespective of the request by interested parties, the court has the power and duty to appoint a trustee where there is none, and one is required to execute an existing trust. The trustee nominated in a will to whom the residuary estate was bequeathed in trust should apply without undue delay for letters of trusteeship, and the right to maintain suit for the appointment of a successor trustee may be barred by laches. Next section, parties on an application. Application for appointment of trustee may be made or resisted by any person interested in the trust, but not by persons having no interest therein. Application for appointment of a trustee may be made by any person interested in the trust, as by a city key trust, creditors, executors of a deceased trustee, guardian of a minor beneficiary, or one of two designated as trustees by the trust instrument, and a contingent interest is sufficient. Persons not interested in the trust apply for appointment of a trustee. Persons not interested in the trust may not resist appointment of a proposed trustee, but an administrator of an intestate who was entitled to receive during his life income from the trust fund is interested in the settlement of the trust insofar as the income due the intestate was not paid, and hence has the right to question the validity of the appointment of the trustee. Furthermore, any person who claims the property alleged to be a trust property as his own has a right to resist the appointment on the ground that there is no trust. Next section, tenant in common of property. The remaining undivided interest of which is held in trust is not entitled to, as a manner of right, to participate in proceedings for appointment of a new trustee to fill a vacancy in the trusteeship, or to maintain a suit for the filling of a vacancy in such trusteeship. Next section, minor beneficiary may petition for appointment of trustee through his next friend. 2. Necessary or proper parties. All persons materially interested in the appointment of a trustee should be made parties to the proceedings, but the rule requiring joinder of all interested parties has been said to be chiefly of convenience and subject to relaxation and discretion of the court. In accordance with the general rule of equity, and under the statute substantially declaratory thereof, all persons materially interested in the appointment of a trustee should be made parties to the proceeding. If they are infants, the court should appoint a guardian ad litem for them. All beneficiaries are not indispensable parties, and the rule requiring joinder of all interested parties has been said to be one chiefly of convenience, not founded on any general principle, and subject to relaxation and discretion of the court, especially when the security for the faithful performance of the trust is required. Although if the accounting as well as the appointment of a trustee is asked for, all interested persons are necessary parties. It has been held to be unnecessary to make those persons parties who are entitled only to future and very uncertain and contingent interests. Under statute, death of a trustee, the court may appoint a new trustee on application of any person interested, and has been held unnecessary to make all persons in interest parties to the proceeding. The rule that all beneficiaries are proper parties in an action to remove a trustee and appoint a new one being for protection of the trustee, he may waive this requirement. Next section, intervention. One without interest in the trust has no right to intervene and may be a party to proceedings for appointment of a trustee, and one denying the existence of a trust has been denied the right to intervene. On the other hand, it has been held that any person claiming the property alleged to the trust property and as his own has a right to appear and become a party to the proceedings. Next section, where there is an absence of essential parties, as distinguished from a mere defects of parties, a decree appointing trustee is absolutely void. Next section, E, notice of application. Jurisdiction to appoint a trustee may be exercised on an ex parte application without giving any notice to any person interested in the trust, and in the absence of any statutes requiring notice, whether beneficiaries shall be given notice of the proceedings rest in the discretion of the court. The jurisdiction of the court to appoint trustees being, as shown subdivision B of this section, quasi-jurisdiction in rem, it is capable of being exercised on an ex parte application without giving any notice to any person interested in the trust, and in the absence of any statutes requiring notice, whether beneficiaries shall be given notice of the proceedings rest in the discretion of the court. Thus it has been held that notice or summons is not in the nature of the process to bring a party into court and give jurisdiction of the person, and that being so, the appointment of a new trustee is valid, although made without formal notice to, and in summons of, those interested, and while it may be irregular or erroneous, and on direct proceeding it may be set aside or reversed, its validity cannot be questioned in a collateral action. The authority of the court to appoint a trustee on an ex parte petition has been denied, however, and has been held that residuary legatees are not barred from questioning a successor trustee's power to carry out the bequests to erect memorials and monuments where appointment of the successor was made ex parte and without notice to the objectants. Notice not to be given to one having interest, nor is notice necessary where the application is interlocutory and in proceedings already pending for administration or direction of the trust, and where all parties are before the court on other. In the connection therewith, a trustee is appointed, no further notice is required. Under statutes requiring notice to specific parties, an order appointing trustees without the required notice is invalid, and the appointment may be vacated on application of an unnotified person. Express requirement of notice in specified cases has been held equivalent to exclusion of the requirement of notice in non-cases. Under statutes providing that the trustee may resign to the register and to notice must be given by publication, and that the register may appoint a new trustee. The registration and appointment of a trustee constitute one continuous proceeding, and not only notice required for appointment is that provided for registration. Next section, waiver of notice. Notice may be dispensed with where parties entitled thereto signify in writing that they're absent to such proceedings or waive your notice, and interested persons acquiescence in an appointment made without notice to them may waive their right to object to its validity or be estopped to question its validity. Next section, F, form and sufficiency of application. Generally, to obtain an appointment of a new trustee, plaintiff must show the nature and extent of his own interest in the trust property, how the trust was created, and why new trustees should be appointed, and he may also recommend the appointee. The fact that the petition is defective is immaterial if no one is misled thereby. Generally speaking, to obtain an appointment of new trustees, plaintiff must show the nature and extent of his own interest in the trust property, how the trust was created, and also why new trustees should be appointed. The authority to apply for an appointment includes authority to recommend the appointee, and the fact that the petition is defective is immaterial if no one is misled thereby. Furthermore, if there was no written application for the appointment of a substitute trustee was filed, should not of itself defeat the power of the court to appoint him. An application for the appointment of a substitute trustee is within the rule that, although the parties are entitled to know their adversary's claims, no cause of complaint exists when that purpose has in any way been subserved, and no prejudice results from lack of allegations provided a cause of action exists and has been shown. Next section, cross bill. When an original bill seeks appointment of a specific person as trustee, it has been held proper to apply by cross bill for the appointment of anyone deemed fit and proper. Next section, amendment. A petition for the appointment of a new trustee is amendable, provided neither the identity of the persons intended nor the subject matter of the petition is changed, and it has been held that within the discretion of the court to permit the filing of an amended cross bill for appointment of trustees. Next section, G, issues, proof, and variance. A trustee may be appointed under a prayer for general relief for the appointment of a trustee to carry out the purposes of the trust, but an order appointing a new trustee is valid where the pleadings do not authorize a change of trustee, and questions of title of persons opposing the appointment or of the respective rights and duties of divisees and legatees under the will not disclosing an intent to establish a trust do not ordinarily arise. A trustee may be appointed under a prayer for general relief, and successor trustees may be appointed under a prayer for the appointment of a trustee to carry out the purposes of the trust, but where the pleadings do not authorize a change of trustee, an order appointing a new trustee is invalid. In a proceeding for appointment of trustees in place of those who had died, the question of title asserted by persons opposing appointment does not and cannot arise. Respective rights and duties of divisees and legatees under a will need not be defined in the proceedings for the appointment of the trustee to administer and trust the residual of the decedent's estate where the will did not disclose an intent to establish a trust. Next section, motion for judgment. In an action against trustee for substitute or additional trustee, defendant's motion for judgment made at the close of plaintiff's evidence was in effect a demurrer to the evidence and raised the sufficiency of the evidence as a matter of law. Next section, H, hearing and reference. Interested parties are entitled to a hearing before appointment of the substituted trustee, which should be fairly and reasonably conducted, and a reference may be had to determine the suitability of a proposed trustee. Interested parties are entitled to a hearing before appointment of a substituted trustee, which should be fairly and reasonably conducted. The beneficiary should be permitted to present reasons for the request that the particular trustee be appointed, but where the selection of a trustee is discretionary with the court, it need not record the reasons for its decision. The appointment of a successor trustee is in effect a holding on that a vacancy in the office of trustee existed and no formal finding of such fact is necessary. A reference may be had to determine the suitability of a proposed trustee. 1. Evidence. Suitability of a trustee to be appointed is a fact that must be proved before the court may make the appointment, and it is also necessary to prove the claim that the existing trustee has refused to act so that a substitute is required, but a prima facie case not conclusively disproved is sufficient to authorize the appointment of a trustee. The suitability of a trustee to be appointed is a fact that must be proved in every case before the court is authorized to make the appointment. It is also necessary to prove the claim that an existing trustee has refused to act so that a substitute is required. A prima facie case not conclusively disproved is sufficient to authorize the appointment of a new trustee. J. Order. The better practice in drawing an order of appointment is to conform to the language of the statute, and generally it must show on whose application it was made, and that the proper parties had not or weren't before the court. The appointment relates back to the inception of the trust, and the order will be given effect according to its terms. The better practice in drawing an order of appointment is to conform to the language of the suit. Generally, the order must show whose application it was made and that the proper parties had notice and were before the court, otherwise it will be invalid. The appointment relates back to the inception of the trust, and the decree appointing successor trustees carries with it such title as such possession as held by the original trustee. An order approving the transfer of assets of a bank in liquidation, which include the bank's beneficial rights in and to the trust instrument under which the bank is named as trustee, cannot be construed as an order appointing the transferee trustee to succeed the bank. An order appointing trustee instead of those who died is not affected title to the trust subject, particularly where it effectively provided that title and right to possession were not affected by the order, and an order appointing a trustee for property bequeathed to the widow during her lifetime and after her death 2, her children did not appoint a trustee for remainder interest. In a decree establishing a testamentary trust, the purpose of a provision empowering the trustee to appoint someone in their place instead to carry out the terms of the trust if for any reason they fail to qualify or are unable to act, as provided a method for appointing trustee in the event those named either fail to qualify or become unable to serve. Where trustees are appointed to preserve the estate and prevent waste, a provision in the decree authorizing them to apply to the court for permission to dispose of the property of the estate is erroneous. Next section, K, costs and expenses. In appointing trustee, the trial judge, in the exercise of his discretion, may provide reasonable attorney fees and other costs for the proceedings which must ordinarily be borne by the trust income. On appointing trustees, the trial judge, in the exercise of his discretion, may provide reasonable attorney's fees and other costs of the proceedings. Ordinarily, such costs must be borne by the trust income, and where the trust deed shows intent to have all necessary expenses of the conduct and management of the trust paid out of income, expenses occur in securing the appointment of a new trustee to fill the vacancy should be paid out of income and not out of the corpus of the trust estate. If, however, legal services rendered to the beneficiary's action to determine who had the power to name the trustee to fill a vacancy burdened the estate and those interested in the estate with an unnecessary litigation, which in the end brought no benefit to the estate, no allowance would be proper. Next section, 1, review. An appeal from an order appointing the trustee must be taken within the statutory time thereby or therefore by an aggrieved person. An appeal from an order appointing a trustee must be taken within the statutory time, therefore, or it will be dismissed. A co-trustee appointed by the trial court but disposed in the intermediate court of the appeal has a party to the record entitled to appeal to the Supreme Court. When designated as a trustee in the trust instrument is a person aggrieved entitled to appeal from the decree denying his petition to be appointed as trustee under the instrument, but if he is incompetent to act, he may not maintain a petition for leave to appeal from a decree appointing another as trustee. Even though an order appointing a successor trustee is revised, orders dismissing the trustee and the latter's receiver and approving the receiver's accounts should be approved on appeal where no objections to such orders were made or called to the attention of the appellate court. Next section, discretion of court below. Where the appointment of a trustee is within the discretion of the court, there is no complaint of abuse of discretion. The decision will not be reviewed. Next section, questions not raised in the court below may not be urged for the first time on appeal. Accordingly, a person who contended at trial that the trust agreement was void is not entitled to assert on appeal that the provisions of the trust agreement with respect to the appointment of the successor trustee should have been strictly followed. Although the trust instrument ordinarily provided for 2 trustees, a party cannot complain on appeal for the decree awarding the trust funds to the trust company as sole trustee that another trustee should have been appointed in the absence of an application for appointment of another trustee in the court below. The fact that beneficiaries of a trust made no motion to vacate an order appointing an individual as one of 2 successor trustees does not stop them. However, to urge on appeal that such successor should not have been appointed. Next section, insurance of letters pending appeal. Issuance of letters pending appeal. In determining whether letters of trusteeship may be issued pending appeal from a decree appointing a successor trustee, reference must be made to statutory provisions, and in the application thereof it has been held that giving of a cost bond on appeal from such a decree does not of itself affect a stay of execution of the decree in the absence of an order of such stay, and that the issuance of letters need not be stayed during a determination of the appeal, but should be limited as provided by statute. Next section is cost. Where the trustee, by direction of the Chancery Court, defends an appeal taken by some of the City Key Trust for the order appointing a trustee, the court may and will award compensation of the trust estate for expenses and legal services so incurred, irrespective of whether or not such defense is possible. And in such case where the object of the appeal was not for the benefit of the trust estate, and where the trustee was successful in defending the appeal, he may properly apply for an award of costs and counsel fees against the appellants, but such application should be to the appellant court. Next section, M, collateral attack. An order appointing a new trustee cannot collaterally attacked unless absolutely void. An order for a court appointing a new trustee, unless absolutely void, cannot be collaterally attacked, although where void, as distinguished from merely avoidable, a decree to order appointing a trustee is subject to collateral attack. Next section, 219, annulment, revocation, suspension, and vacation of appointment. Although an unauthorized appointment of the trustee will not be disturbed in the absence of a showing of an abuse of discretion by the court in making it, an unauthorized appointment will be revoked on timely application by an interested person. Although an authorized appointment of a trustee will not be disturbed in the absence of a showing of an abuse of discretion by the court in making it, an unauthorized appointment will be revoked on timely application. The court has the power to vacate an order of appointment on the application of anyone interested in the estate who had no notice of original application, so as to give such a person an opportunity to be heard as to either method of executing the trust or the person designated to execute it. A stranger not interested cannot question the right of a trustee to act as such or raise a question as to the want of jurisdiction of the court appointing a trustee or as to the regularity of the proceedings. Nor can parties participating in a proceeding by appearance subsequently question the validity of the appointment. Next section, annulment, where the appointment of a trustee is by an interlocutory decree, a subsequent dismissal of the bills annuls the appointment, annuls the appointment. Next section, suspension. It has been held that an order appointing a trustee as administrative and may be suspended by another chancellor under the provisions of some statute the court made on application of the trustee or of some for some person interested in the trust suspend the powers of a trustee engaged in war service during the period of such service. Next section, proceedings. A petition for revocation of a decree of appointment is proper remedy of an interested party not qualified or not notified of a proceeding for appointment of a trustee. A proceeding to set aside an ex parte appointment of a successor trustee to appoint a trustee nominated by the beneficiaries should be regarded as a review of ex parte appointment and not as an application for removal of one appointed as trustee, and the beneficiaries nominated should be given the same consideration as though made prior to the ex parte appointment. Where the judge in a proceeding to revoke a decree appointing a trustee did not appoint another than the guardian of a beneficiary's minor child to represent the minor interest, such guardian was entitled and under the duty to represent such minor's interest therein, and where no appeal was taken on behalf of the minor for the decree dismissing the petition, the effect of the guardian's offer to ratify such appointment in the minor's behalf filed after entry of the decree revoking the decree of dismissal need not be considered on an appeal for the decree. A trial judge, after entering a final decree on the merits dismissing the petition for revocation of the decree appointing a trustee, is not authorized to revoke such final decree on the ground that it did not clearly appear at the time of the trial that the minor child was interested in the petition and the petitioner's sole remedy was by appeal. The trustee has a right to appeal from a decree revoking his appointment. Next section, 220, statutory substitution of trustees. Under statutes providing for an automatic substitution or succession of trustee under specified circumstances, a testator who voluntarily designates as trustee a person or body within the statutes must be deemed to have adopted the statutory scheme, and such substitution may take place without court action. Under statutes providing for an automatic substitution or succession of trustee under specified circumstances, a testator who voluntarily designates as trustee a person or body within such statutes must be deemed to have adopted and included in his declaration of trust the statutory scheme, and such substitution may take place without court action. Probate courts are under a duty to recognize new trustees succeeding by operation of law unless the statute is void as offending some constitutional provisions, have no jurisdiction to hear or determine any protest against the statutory substitution of trustees, and if any rights are reserved to the beneficiaries to object to the substitution, they may be asserted in the court of equity. Consist of the beneficiaries of testamentary trust consent of the beneficiaries of testamentary trust is unnecessary to Unnecessary to statutory substitution of trustee. Next section, 221, changing number of trustees. Generally, where trustees retire, their place be filled by the same number of new trustees, since the courts are reluctant to change the number of trustees from that designated by the creator of the trust, but the courts may and will increase or decrease the number of trustees when it is necessary or desirable. Generally, the rule to be adhered to is that where original trustees retire, their places should be filled up by the same number of the new trustees, and the courts are reluctant to change the number of that designated by the creator of the trust, and on substitution there should generally be an adherence to the original number of trustees. It seems to be in accordance with reason and authority that the court may change the number of trustees when, by the reason of changed conditions in the estate, a number designated by the creator has become excessive or insufficient, and it is necessary to reduce or increase the number in order to effectuate the execution of the trust. Next section, authorization and trust instrument. If a trust instrument is so worded as to authorize the number of trustees to be changed, this may be done. Next section, increasing number. In appointing new trustees, the court is not limited to the number originally named, but may and will increase the number as occasion demands. Only in very exceptional and rare cases, however, will this be necessary or justifiable. In granting a trustee application for an appointment of additional trustees, the court may impose a condition that the present and additional trustees agree to accept commissions for all in the sum to which the single trustee would be entitled, or that they waive the statutory commissions and consent to receive in full payment of the services to be rendered such amounts as to the court may fix as reasonable value thereof. Next section, decreasing number. In reducing the number of trustees, the court will act with caution. Thus has been said to the contrary to the courts of equity to commit a trust to the care of a single trustee where there was originally more than one. Although appointment of a sole trustee is within the power of the court, the justified under special circumstances or where it appears that such action would benefit the parties interested. So in the absence of a clear manifestation of the intention of the creator of the trust that a specified number of trustees should always act and never be diminished, vacancies will be filled only if necessary or conductive of the conditions of the continuous proper admission of the trust, and where no such necessity is shown, a new trustee will not be appointed, but the remaining qualified and acting trustee will administer the trust. Next, section C, qualifications. Section 222, compliance with requirements in general. A trustee should comply with statutory requirements as to qualification and with the formalities of appointment, but irregularity in connection therewith will not necessarily invalidate his acts and administration of the trust estate. A trustee should comply with statutory requirements as to qualifications, and it has been said that both an individual and a corporate trustee should comply with the formalities of appointment before acting, but statutory provisions outlining the procedure for the qualification of a trustee are inapplicable to the qualification of a testamentary trustee under the will of a deceased, which becomes effective on the date of the decease prior to the effective date of the statute. Although there has been some irregularity in connection with the trustee's qualification, such irregularity will not necessarily invalidate his acts in the administration of the trust estate. It has been held that the title to property which is passed to a trustee by his acceptance of a deed of trust is not divested by his failure to qualify, and the failure of a substitute trustee to qualify as trustee by making bond and taking oath did not invalidate his appointment or vitiate judgment rendered in his favor against the original trustee. Next section, trust to be administered outside state. Statutory provisions which respect to the qualification as trustees apply only when the trust is administered within the state, and it is unnecessary for a trustee appointed in a foreign country to take out letters of domestic form of original probate jurisdiction. Next section, 223, oath. Statutory requirements as to the filling of an oath by a trustee are founded on the necessity of having some formal record of the trustee's assumptions of duties and some formal qualifications by him, and an inadvertent failure to file a prescribed oath may be cured. Statutory requirements as to the filing of an oath by trustee are founded on the necessity of having some formal record of the trustee's assumption of duties and some formal qualification by him, has been held that an inadvertent failure to file a prescribed oath may be cured by subsequently filing under order of court. Next section, 224, bond. A, requirement. In general, a bond is not inherently essential to the existence of a trusteeship, and where the matter is not otherwise regulated by statute or provision of a trust instrument, the question of whether a trustee will give bond is addressed to the discretion of the court. A bond is not inherently essential to the existence of a trusteeship, where the matter is not otherwise regulated by statute or provisions of the trust instrument. The question of whether the trustee should give bond is addressed to the discretion of the court, which may in the proper case omit the requirement, or by virtue of inherent chancery jurisdiction over the trust estate, may require the execution of a bond for the faithful administration of the trust. Next section, implied trust. A trustee may be compelled to give security for the trust property, although the trust results from operation of law alone. 2, under statute, a trustee must give bond where required by statute and may not be compelled to give a bond where the statute expressly provides that no security shall be required. A trustee will give a bond where required by statute and may not be compelled to give bond where the statute provides that no security shall be required. A statute authorizing a court to direct a fiduciary to deposit securities belonging to an estate in lieu of bond is constitutional. Under some statutes, if no bond is given, it is competent for the court to order execution of an adequate bond. Statutes providing that where any person interested in a trust created by will or deed shows that it is necessary for the safety of beneficiaries to require security of a trustee, the trustee appointed shall give security, are intended to afford full protection and all interested in the trust property, and the court may properly require a bond on showing that the trustee has made a hazardous investment of trust funds. Under a statute providing that every trustee appointed by a deed or other written instrument to hold, manage, or dispose of property for another may be required to give bond, a naked trustee may be required to give a bond. Under statutes requiring bond of a trustee whom real or personal property is limited or conveyed for creditors or for sale for any purpose, a bond is required of a trustee holding property for sale, although not technically a trustee for creditors. But no bond is required of a trustee to whom property is limited or conveyed to hold until specified time and when to distribute, then to distribute, and the fact that such trustee is given an incidental power of sale does not bring him within the purview of statutes. Under code provisions requiring a bond of every trustee or assignee to whom the property exceeding the prescribed value is conveyed in trust for creditors, unless released in writing before entering on duties of his office, it is the error for the court to appoint such trustee without requiring bond where the property is of a specified value and the beneficiaries have not waived a bond. Next section, testamentary trustees are generally required to give bond under statutes so providing, although under some provisions bond is not required where contrary to the terms of the will. Statutes providing that testamentary trustees shall give bonds have been variously construed as mandatory or as directory only, and is applicable both to trustees who are also executors and to persons not executors but designated in the will as trustees. Under mandatory statutes requiring bond, a bond is essential to the official character of the trustee to perform the trust and is prerequisite to his power to act as trustee. Statutes held inapplicable to testamentary trustees include statutes requiring bonds of executors and administrators, statutes requiring bonds of testamentary guardians, and statutes requiring bonds of trustees for creditors. Under statutes entitling remainder men to security for proper administration of a trust, one holding in trust for remainder interest will ordinarily be required to give a bond, although where the designated trustee has discretionary power to expend the whole income and principal for his own personal use, no bond will be required in the absence of proof of waste or diversion from personal use. Next section, retroactive character. Statutes requiring a trustee to give bond while having been construed as applicable to deeds of trust executed before their enactment unless containing a provision against retroactive operation. 3. Under provisions of trust instrument. In the absence of controlling and mandatory statute is optional with the creator of the trust to require a bond or not, and if the trust instrument is silent as to the security or expressly dispenses therewith, none will ordinarily be required unless the court, in the exercise of its discretionary power, deems it necessary for the protection of the estate. In the absence of controlling and mandatory provisions of statute, it is optional with the creator of the trust to require a bond or not. So although it has been held that the directions of the testator touching bond and administrative matter may be disregarded in effectuating the substantive property rights created by the instrument, the view has been taken that where the instrument expressly requires a bond, the trustee must give a bond, regardless of his financial worth, before assuming his duties. Next section, absence of provisions as to security. Where the trust instrument is silent as to security and there is no controlling statutory requirement of security, the court should not exercise its discretionary power to demand a bond unless on a showing of probable loss or other equitable grounds for a bond, and will not ordinarily require security of the trustee in the absence of waste, mismanagement, insolvency, or the like, particularly where sufficient protection has been given by a requirement incorporated in the decree that the trustee obtain the approval of the court before completing any sale or purchase of property, and make annual reports to the court of transactions pertaining to the trust estate. But under its discretionary power, the court will require a bond in such cases where that seems advisable for protection of the trust estate. Next section, provisions dispensing with security. If it is the clearly expressed purpose of the author of the trust that the trustee shall not be required to execute a bond, none will be required unless in pursuance of some express statutory requirement, or unless there is a reason to apprehend that the safety of the estate demands it. Thus, even though the settlor has excused the trustee from giving security, the court may require it, and should do so on motion of the sedicee trust, where the power or authority of the trustee to do, enact, or make a sale is derived from, or where it is appointed by the court. The statute requires the execution of a bond as a condition on which the appointment may be made or the power exercised. The power can be conferred only on the statutory conditions without respect to the wishes expressed by the author of the trust. A provision of the trust instrument dispensing with security will ordinarily be limited to those designated as trustees therein, although such exemption from bond may be extended to include persons designated as alternative trustees. B, amount. Subject to the applicable statutory provisions, the amount of the trustee's bonds rests on sound discretion of the court, and bonds should be furnished in reasonable amount. Subject to applicable statutory regulations, the amount of the trustee's bond rests in the sound discretion of the court, and the bond should be furnished in reasonable amount in view of the value of the property and other applicable circumstances. Under local practice, it has been held that the penalty of the bond should be equal to double the value of the trust estate, but the direction of the instrument creating the trust will control, and it has been held that the court has no power to reduce the amount of the bond required therein. Next section, C, form, requisite, and sufficiency in general. The court may at all times regulate the sufficiency of a bond. Its first duty relies on the preservation of the estate, and to that end it has a wide discretion in bond matters. The bond must be enforceable in a court of law, and approval of the court is ordinarily required, but mere informalities will not necessarily invalidate it. The court may at all times, on application of its own motion, regulate the sufficiency of the bond. The first duty of the court lies in the preservation of the estate, and to that end its discretion in bonds matters is ordinarily wide and unfettered. A trustee's bonds must be so executed as to be enforceable in court of law, and approved by the court is ordinarily required. Mere informalities will not necessarily invalidate such a bond, and even though void as a statutory bond, it may be held good as a common law bond. Next section, joint or several bonds. Where there are separate beneficial interests to be protected, separate bonds may be required, or in the absence of a requisite thereof, a joint and several bond will be approved. D, sureties. Unless the bond without sureties is authorized by statute, the bond of a trustee should be a bond with sureties of a prescribed number, and the sureties should reside within the jurisdiction of the court. Unless the bond without sureties is authorized by statute, the bond of a trustee should be a bond with sureties, of prescribed number, and the surety should reside within the jurisdiction of the court, particularly where the trustee is himself a non-resident. A probate judge may be authorized to authorize his administrative clerk to qualify the personal sureties on the bond of the testamentary trustee, subject to the necessity that the approval of the bond per the order become the act of the judge. Next section, discharge. In accordance with the general rules, and surety for the trustee may not be relieved of further liability of his mere arbitrary demand. An order of sureties for a former bond on the furnishing of a new bond is so far final and conclusive as not to be subject to collateral attack. Next section, E, effect of failure to give surety. While the trustee is not authorized to accept the trust and administer the trust estate until he has given required surety, a trust is not defeated by failure to give surety, and the fact that one named as a trustee of a testamentary trust is not qualified by giving bond does not prevent him from becoming a trustee by virtue of being so named in the will. While the trustee is not authorized to accept the trust and administer the trust estate until he has given required surety, a trust is not defeated by failure to give surety, and it is intended for the benefit of the beneficiaries, and they alone have the right to complain, and such failure will not invalidate the acts of the trustees. So in the fact that one named as trustee of a testamentary trust has not qualified by giving bond does not prevent him from becoming a trustee by virtue of being so named in the will, as where the statute provides for that failure to furnish a bond within the specified number of days after notice that the bond is required amounts to a declination of the trust. But in such case, the failure to qualify amounts only to a resignation of the trustee, or as shown supra, section 60, to the declination of the trust, which presupposes the existence of a trustees prior thereto, and subsequent filing and approval of the bond has been effect of a reappointment as trustee. The trustee's failure to give bond may not be made the subject of a collateral attack. Next section, title. Where a statute requires bond of trustee for creditors for sale of property, title does not pass to the trustee without bond. Here, however, the statute provides that any person appointed trustee by will who shall refuse to give bond or neglect to do so for 20 days after receiving notice that such bond is required shall be deemed to have declined the trust. Failure to give the required bond does not prevent title from vesting in the trustee immediately on the death of the testator, and for 20 days after receiving notice the bond was required, and the fact that one named as trustee in a testamentary trust has not qualified by giving a required bond does not prevent him from obtaining title as a divisee, and as shown infra, section 241, if he has been designated both executor and trustee but fails to qualify as trustee by giving a required bond, title may remain in him as executor. Next section, where no bond is required, the failure of a trustee to furnish bond does not make him a trustee de son tort. Section F, new or additional surety, additional security, Where so empowered by statute, the court, on application of a party interested, has the right to require a trustee who has given insufficient bond to give an adequate one. Where so empowered by statute, the court, on application of a party interested, has the right to require a trustee who has given an insufficient bond to give an adequate one. Statutes broadly empowering the court to require a new or additional bond on application of an interested party, if deemed necessary, should receive such reasonable and liberal construction as the common sense that justice in the case may require, and under such statute has been held that the trustee may apply for a new bond, and that new bond may be ordered not only to protect the estate from possible loss, but also to reduce expense protection. Next section, proceedings to require bond. The court has no authority to require a bond of a trustee in the absence of some sort of proceeding beginning the question before the court, or bringing the question before the court, but a court having charge of the fund may require a bond to protect it either on the direct application or when it appears that the circumstances of the case require it. A court has no authority to require a bond of a trustee in the absence of some sort of proceeding bringing the question before the court, but a court having charge of fund may require a bond to protect it either on direct application or when it appears that circumstances of the case require it, where a will expressly requires bond of a testamentary trustee and the amount to be fixed by court The proceedings of this purpose should be begun in the proper court. A proceeding by motion has been held permissible in the absence of objection, and a statutory proceeding to compel testamentary trustees exempted by will to give bond has been held exclusive. Next section, who may maintain. Generally speaking, a proceeding to require a bond of a trustee may be maintained by anyone interested in a trust estate, but not by a stranger thereto. Next section, notice and summons. In an application to require a trustee to give bond, it has been held that no summons or service thereof is necessary, but simply a reasonable notice of such application and its object. No notice is necessary to approve of a bond of a trustee named in the will creating a trust. Next section, pleading. In making an application to require a trustee to give bond, it is sufficient to allege therein the interest of the applicant, the nature and the amount of the trust, the fiduciary capacity of the trustee, and that he has never given bond to secure the preservation of the trust funds and the execution of the trust, and to pray that he be required to give such bond. H, new or substituted trustee. A new or substituted trustee must, unless it is waived, give bond if required to do so by statute or by the terms of the instrument appointing him, but if not so required, he need not give one unless ordered to do so by the court in exercise of its equitable jurisdiction. A new or substitute trustee must give bond if required to do so by statute or by terms of the instrument appointing him. If not so required, he need not give one unless ordered to do so by a court in exercise of its equitable jurisdiction. A statute requires that a trustee appoint to fill a vacancy in a testamentary trust must give a bond before acting is for the benefit of the creditors and beneficiaries of the trust and may be waived by them. Next section, provisions of a trust instrument dispensing with security has been held not to extend to a new or substitute trustee. Next section, new trustee appointed by donee of a power of appointment cannot, in the absence of a provision, therefore, in the trust instrument, be required to give bond unless he is of doubtful responsibility. Next section, original petition for cancellation of substituted trustee bond given pursuant to direction of decree of court regularly made will not lie in the absence of a provision of law authorizing it. Next section, I, non-resident trustee and resident trustee under foreign wills. Where the matter is not otherwise regulated by statute, it is discretionary with the court to require security from a non-resident trustee, but ordinarily a court of equity will not appoint nor substitute a trustee resident in another state without security. Where the parties in the trust estate are within the territorial limits, a court presiding a trustee resident in another state without security. Where the parties in the trust estate are within the territorial limits, a court possessing equity powers has inherent jurisdiction to exact and approve the bond of resident trustees appointed in the foreign will or of his successor. Where the matter is not otherwise regulated by statute, it is discretionary with the court to require or dispense with security for a non-resident trustee. Non-residence within itself is, in absence of testamentary provisions to the contrary, is generally held to involve such hazard, inconvenience, and expense to the remainder man as to endanger their interest to such extent that the security would be required, or the estate retained under the jurisdiction of the court and managed by the trustee of the appointment of the court. Accordingly, a court of equity will not ordinarily appoint nor substitute a trustee resident in another state without security for the faithful discharge of his duties, although the court may omit the requirement of a bond where it appears that the foreign trustee is a corporation of high standing or has given adequate security in the state of his residence. The question of safeguarding the rights of the beneficiary should be determined in advance, not after the property has passed into the keeping of the non-resident trustee. Where the parties in the trust estate are within its territorial limits, a court possessing equity powers has inherent jurisdiction to exact and approve the bond of a resident trustee appointed in a foreign will or of his successors. Next section, under statutes requiring bonds of non-resident trustees, it has been held that a non-resident trustee must file a bond to become entitled to home assets, and the provisions of the trust instrument exempting him from giving bond do not obviate the statutory requirement. statutes regulating the qualification of testamentary trustees under wills of residence and providing for bond are inapplicable to trustees appointed under the will of a non-resident, but where the resident trustee is appointed under the will of a non-resident and the foreign will has been recorded in the state and the trust consists of realty within the state, the court may in its discretion require a bond, and if on petition to fix a bond of such trustee it is uncertain whether or not the co-trustee will qualify, a citation should be issued to the latter or his renunciation should be filled. Next section, removal from state after creation of trust is sufficient to justify the court in depriving the trustee of custody of the trust funds unless he executes a sufficient bond. Next section, D, resignation, discharge, and removal. Section 225, resignation and discharge in general, on page 181. We will pick up there next time on page 181. Section 225, resignation and discharge in general. Let's switch over to the Q&A.
Unmuted. Muted. Q&A session started.
Press star 6, star 1 to get in the queue line. Raise your hand. Press star 6, star 1. Floyd, you're unmuted.
Yeah, Christian. When we invoke the judge, for example, as trustee in our trust, are we calling his bond to account?
No, we haven't even mentioned anything about a bond. This is more or less for a statutory trust on the statutory side.
Yeah, I know. But
a private trust.
I was just wondering if his bond would come into some kind of an action if we make him trustee in our trust.
Say that again. If his bond would come into action in our trust?
Yeah. If he breaches the trust, would that affect his bond?
I mean, if the judge had a bond for being a judge, or the bond that we're going to give him for being trustee?
No, he has a bond for being a judge.
Is that the one you're talking about?
Yeah.
Yeah, that would be accessible to get after that one because he breached the trust, especially if he didn't say, if he disclaimed and he went after, and he didn't appoint a new trustee after resulting trust formed.
Yeah, because that's what his bond is supposed to be for. If he messes up, that's supposed to that's supposed to back him up or pay fines or whatever it is that it's supposed to do for him.
Another point there, that would be a breach of the bench, and then that would directly bring in his bond for the bench.
Yeah. Yeah, that's something that they need to be considering too if they start messing around with breaching the trust that we're bringing him into.
Yeah, but I don't want to come after the bonds and things on the public side because that's public. I want to stay in the private, and I don't want to commingle on that public side at all.
Well, I'm not thinking so much about going after his bond as I am about using it as something that you could just make him aware of, whether you do it or not.
Yeah, you could always make it known to him that you could come after his bond, but if we have to give them a bond, like what they're talking about in the statutes here, that's just something else I gotta end up extinguishing.
Yeah.
In the court of equity, and I'm going to get the court of equity to force them to do the performance because I want the performance.
Yeah, right. I understand that. I was just thinking that would be another handle that we'd have on them.
Yeah, but we're going after all this stuff. You know, if we just stick to the basics, I think we're more than well enough equipped.
Yeah, well, I understand it. Okay. Well, I'll talk to you some other time about the bond in regard to what we're attempting to do with the set of key trust, I guess, because I'm still not quite clear on that as to what we're doing and how we have to do it.
Any other questions?
No, that's it. Thank you.
Floyd? Doyle, you're unmuted. Doyle, you're unmuted.
Hello, can you hear me?
Yes.
Christian, I wanted to revisit the issue that we talked about a few days ago concerning expressing a trust with the bank account. Do you remember that?
Very vaguely. They're all the same, though.
Yeah. Well, if you don't mind, I'd like to read the letter that we got in response to our expression of the trust and the indenture that we sent to the CFO of the bank.
Okay, sure, go ahead.
Okay, it says, Dear Mr. Smith, RBS Bank has requested that you close the captioned account on or before July 23, 2010, or RBS Bank will be issuing a cashier check for the balance of funds in the captioned account at that time. In response, you have provided various correspondence and a purported trust indenture, constructive notice to RBS Bank, directed to Dennis Smiley, trustee, in quotation marks. Please be advised that RBS Bank does not recognize and does not accept any trust, in quotation marks, relationships with you or any other third party with respect to the captioned account. Nor does RBS Bank recognize any special deposit, in quotation marks, referenced in your correspondence of July 16, 2010. RBS Bank rejects the July 16, 2010 correspondence in its entirety. You hereby are directed to take immediate steps to close and transfer your account to another financial institution. If the July 23, 2010 closing date should present an unusual hardship, you need to make immediate arrangements with Yuba Phillips or Rhonda McNally at phone number to cover any checks which may be presented to RBS Bank on or after July 23, 2010. If you have not made appropriate arrangements with RBS Bank or otherwise closed the captioned account by July 23, 2010, RBS Bank will close the captioned account and forward any remaining balance to you at the above address. Sincerely, Yuba Phillips, Senior Vice President, Operations. And then it's also CC'd to Rhonda McNally, Dennis Smiley, and Janice Lyons. So question is, what's the next step?
Well, I wonder why they keep ordering you to close the account. Why don't they just close it and then just send you the whole thing?
I don't know. Are they not aware that a bank account is a trust?
Yeah, I think they're fully aware of that, and they want you to close the account voluntarily.
Okay.
Because I don't think they can close the account.
Uh-huh.
Well, they may have threatened. They said that they're going to, but that doesn't mean that they can or can legally, let's put it that way.
Well, I checked online. I went to my account and checked online the other day, after Friday. I left a little bit of cash in the account, not much, but the balance said a negative amount, whatever it was, and I have not yet received the check, so I don't know whether they have actually closed the account or they've just made the funds unavailable or what the deal is. So I guess the question is, do we need to send them photocopies of the CJS, or how would we proceed?
Oh, what was the trust res? What was the trust res?
Well, the original signature card.
Okay.
Because this wasn't an existing account.
Say again?
It was an existing account.
You say it was an existing account?
Yes. So they are in possession of the signature card and have been for some time.
So they didn't send you anything back like the signature card, did they?
Not that I'm aware of, no.
And you didn't request it back, did you?
No.
Well, I would say if you did the elements of the trust and the method of formation, you've got a trust, and now they're in between a rock and a hard spot now, trying to get out of it.
Mm-hmm. Well, we sent the indenture with all of the elements, parties, purpose, intent, and the notice of formation, and the transfer of the, they already have the trust res, so I notice that they are in possession of trust res.
So what was your specific purpose for the account? Did you have one in there?
I don't remember exactly what the specific purpose was. I can pull it up on the computer and kind of review it.
That's what you got a public side.
Sorry about that. I think the purpose was something along the lines of a lawful, something that would be lawful and, not unlawful anyway.
So was there a specific duty with the appointment?
I think the request was that RVS Bank would monetize the signature and send funds to a public account.
Okay, so if that was an order, then that's the specific purpose or duty that they've got an obligation to. Now, if they don't do that, was there a time limit, a certain amount, or some kind of stipulated time?
No, I don't think that there was any time limit. It was basically further directions would come, follow.
Okay, give them some further instructions then.
Well, it says 14 days after receipt, convert trust res to fully appropriate funds to extinguish any debt. Now, that probably would
Did you put any debt in to extinguish?
No, not in the bank account, no.
Maybe you should do that.
Write a check?
No, send a bill.
Oh, send a bill. Oh, okay.
Send a debt bill.
Okay. Well, this is convert trust res to funds brokered to extinguish debt by monetizing the signature. 2, provide a complete accounting of all transactions. Number 3, deposit funds into a public account as needed. Account number to be provided.
Did you provide the account number?
We haven't asked for any funds.
Well, you've got a lot of things that you've planned, but you don't seem to be completing them. What you planned, what your purposes were. So that's what you need to be doing next.
So I need to be telling them what I want them to do.
Yeah, don't just
Well,
say a nasty letter. Give them some orders.
It says here, we do not recognize anything that you have sent.
Well, that's fine. We'll take it up with the court then. So, but anyway, give them orders anyway.
Okay. Well, I can send them a bill. I'm sure I can find one to send to them.
Yeah, send them a bill and tell them take care of this, discharge this, with extinguish the debt.
Uh-huh. So it might be that simple, huh?
Yeah, it might.
Well, that would be cool. Would this also apply to a credit card as well?
Yes.
I am in the process of expressing a trust on a credit card, and I went to court last Friday, and I had several petitions in order or in line to be considered. So the judge called for a motion hearing, or petition hearing. I guess she called it a motion hearing, and she dismissed a couple of my motions. But while I was there, I requested a special appearance with her in private to discuss special matters related to this case. And she was very receptive to the idea of having a meeting in chambers, and she kept pointing out and kept stating that anything that was discussed in the private chambers could not be put in as evidence. And she stated that 3 times. So I guess my question is, when I get this special appearance or this appearance in the chambers, in addition to presenting the UCC1s and the UCC3s as evidence of the formation of the trust with indenture and the transfer of trust res, is there a special, I mean, as far as language, because one has to be, I think you emphasized many times that one has to be careful to not traverse in language with the public language versus private language. Is there words that should not be used when discussing these paper or these documents with her in chambers in the company of the opposing lawyer?
Yeah, I would stay away from statutes and codes for quoting something in chambers with statutes and codes and things. I would stick with maxims.
Mm-hmm.
Maxims are under equity. That's what I would do.
Mm-hmm. What about taking in a copy of the CJS with us?
Well, the whole purpose of this hearing is for what?
To express a trust with a credit card and request that the trustee, who will be the CFO of the credit card company, to extinguish the debt with the trust res, pretty much the same with the bank account. Take the trust res, monetize the signature, and extinguish any debt that they claim that's owed.
So what's your first step in chambers?
Well, I'm assuming that my first step in chambers would be to announce to the judge that I'm there to express trust in this case, and immediately present the certified copies of the UCC1, the UCC3s, 1 and 2. And
trust has already really been expressed. You're there to, if there's any question, to prove it. A trust has already been executed.
Okay.
As soon as the trust res is in the hands of the trustee, the trust is executed. It's in existence. Only if somebody questions it that you got to prove it. So you have to know how to prove the trust if somebody questions it.
Okay. So
now, they may not question it. They may say, "Oh, yeah, okay, I see a trust here, and now what? You know, you can go on." But let's just say that they say, "Well, I don't see a trust." What do you do then?
Well, then would you not proceed with your evidence of your formation of the trust, and that would be your claiming all rights, titles, and interests, and then the withdrawal of any general deposits, and then the UCC3, which indicates the redepositing of all general deposits?
Exactly what do you mean when you say all that?
As far as what does it mean to withdraw general deposits?
You know, basically, let's go. First thing we have to do is to prove the trust. Let's say they say that I don't see a trust. Now you got to prove to them that there is a trust. Now how are you going to do that?
Could one not come forth with an indenture and show where? I guess you would need to have a indication that you
have you read Gilbert's law summaries, Law and Trust?
Yes, we've read it with you, read along, and
okay.
Followed.
But what are the basics, the basic test of a trust? Because you have to test the trust.
Okay. Are you referring to the elements of the trust?
Yes. Yes. Yes.
Okay. So you have to have your purpose and your intent, and then you need to have the other four elements of the parties, the trust res, and the parties need to be named, like the grantor and the beneficiary and the trustee. Intent, and then indication of the transfer or the formation of the trust, but via transfer, and that would be
right. So you've got intent, purpose, all the parties, and you've got specific res that was delivered, and you got the proof for all that. Then the law must recognize this to be a trust.
Right.
Now they have to say, yeah, I see a trust.
Mm-hmm.
Now you prove the trust. There's no question there's a trust here.
Mm-hmm.
Now you can make a claim against the trustee that he didn't do the duty that he was assigned specifically for the indenture then.
Uh-huh.
And once you make a prima facie case for that, if you're in chambers in equity, the trustee is presumed to be guilty.
Mm-hmm. And one should be able to do that within, say, 2 minutes of the time that you meet the judge?
Yes, because I would tell the judge, I have intent, I have purpose, and I would be, spelling out. Well, here's the indenture. It says, here's my intent, here's my purpose. Here's the specific res. I'm the grantor. There's beneficiary here that may be named in chambers. Trustee is so-and-so. The method was the delivery. He's got the green cards here to prove that he received it. They've got trust res. Now there's got to be a trust.
Mm-hmm. Okay.
Now, if the special depositor or the indenture had instructions in there for what you were saying to do a discharge or whatever debts were things for a specific purpose, then if that trustee didn't do that and you make an accusation that he didn't, now it's presumed that he didn't, and now the burden of proof is on him, and he's presumed to be guilty already.
Mm-hmm. Okay, so now this lawyer who represents this credit card, is he going to be able to say anything other than what's going on here?
I don't believe so. If he does, you could shut him up right away because he's at law and can't be seen in that courtroom in chambers.
Well,
only as a real man.
It was interesting in the court when I asked the judge if it would be okay if I came and spoke with her concerning special matters, that I wanted to discuss special matters related to this issue. And he stood there with his mouth open and had no idea what was being discussed other than he would be there. So is he really that clueless?
Yes. This is a different color horse. And the at-law side attorneys and the court is going to be very astonished about what comes down.
Uh-huh. And we'll know it when they see it.
No, they won't know it when they see it.
Or the judge, but the lawyer may not.
The judge will probably know.
Yeah. The judge had the lawyer, of course, he acted pretty dumb, and he may have not been acting.
He is dumb because he has absolutely probably no idea what you're talking about.
Uh-huh.
Because he is solely at law.
Yeah. Well, he indicated he had no idea what special matters were or special matters relating to special issues No
Yes.
clue. Okay.
Probably not. You're in a different realm than him. You're on the private side now.
Well, he may
As long
not.
as you keep talking about rights, it was your right that the trustee perform according to his duty, and if he breached, I want a specific performance from him.
Right. Well, that was one of the things I mentioned to the judge in the in the courtroom was that I wanted to express my substantive rights, and so it seemed to turn on a light for her because when I requested the in-chamber hearing to discuss special matters, she was very receptive. And in fact, said, "Oh yeah, I'd be glad to hear you or have you come and discuss this in private. And you set up a time, let me know when you want to come, and we'll discuss it." So,
When do you get that out of a judge?
beg your pardon?
When do you ever get that out of a judge?
Well, that's what I was thinking. I thought, well, geez, is it this simple? I mean, everyone was saying that it's difficult to get in chambers, but here I asked her, and she said, I mean, she was very bubbly and was very, very receptive to the idea and said, "Oh, yeah, whenever you're ready, you just come and let me know and set up an appointment with my secretary, and we'll sit down and talk."
There you go.
Well, I'm excited then if it's this simple.
Well, this may be a good point to bring in something here. I don't tout on successes, but there was an unlawful detainer hearing. And if anybody doesn't know about an unlawful detainer hearing, that is solely about possession.
Yep.
This was on a foreclosure that, by operational law, the house was foreclosed. It was sold, and now that's a done issue.
Right.
The detainer action is solely something different. It's only about possessory rights, and it's got to do with a leasee and as a tenant. Now, if the previous owner is living in the house, he is the previous owner, and he's not a leasee. And at that point, at this hearing, they will kick out the previous owner because he's not the tenant and has no lease. Because that hearing, that unlawful detainer, is only there for a leasee if he has a valid lease, and to talk about that. And everybody wants to come up and argue about the foreclosure issues as being an owner, and you can't talk about that there. They will ignore that. That's not what they're there for. Two separate issues. So this detainer issue, this hearing, this attorney for the plaintiff was going to be expecting to win as usual because the defendant was going to argue about the mortgage foreclosure instead of about the possessory rights and the leasee.
Right.
He expected a win automatically. I don't know how long it said, but he said 5 lines, 5 basic things on an expression of the trust. And the attorney was not paying attention because he expected to win.
Uh-huh.
And all of a sudden, there was a retrial of the new, and this guy didn't know what happened. He was so shocked, he asked the defendants in the hall 3 times, what happened in there? He said, in all my life as an attorney, I have never seen a detainer hearing get rerouted to a new trial. What went on in there?
Mm-hmm. So basically, what he did was he expressed the trust in the court.
Yes.
Well, for all those people who are facing this issue of a detainer hearing or a detainer hearing, take note.
But the amazing thing is that this attorney expected to go in there and to win hands down, and he was so flabbergasted that he didn't know what would happen because he wasn't really paying attention, and he didn't know, didn't understand. But this guy came in and expressed the trust, and the whole trial that hearing got canceled, and it got rescheduled into a new trial.
Mm-hmm.
And probably equity is going to be under multiplicity of suits, condense the two back into the one, and is going to go probably back in from the detainer issue back into the mortgage foreclosure if he does it right.
Right.
And probably open up that mortgage foreclosure issue again.
Mm-hmm. Even though they've already sold the property.
Even though they've even sold the property.
Uh-huh. Well, very good.
But
I have a question about the UCC filings. We did a UCC-1 filing, and we put in the company in line, or the first part of the where you put in the I guess the debtor and the organization, and then the name on the next entry. The filing came back from Kentucky, and they said non-indexed. Is that an issue that we should be concerned with, or is that something we need to address?
Non-indexed?
Yeah, that's the copy came back with that part of it stamped non-indexed. They just took a stamp and stamped on top of it non-indexed.
Okay, did you call them up and ask them what that meant?
No, I don't think we did. They sent some paperwork, a couple items on the piece of paper, but they did not explain what non-indexed was or what it meant. We looked on the instructions, and it says that you need to know the EIN of the company and all of that information. Well, on some of these companies, credit card companies, it becomes rather dubious to locate some of that information. Is that something that we need to track down and put out on the UCC filing, or is it important?
Oh, possibly, but I would call them direct and find out, out of their own mouth what they mean, what's it deficient by.
Uh-huh. Okay.
Sounds like it needs to be indexed back to something. And this was, what, a UCC-1?
Yes. We're filing for the all rights, titles, and interest claim, say on a credit card or a bank account or whatever it is.
Yeah, well, I would call them up direct because they probably got a hotline or a question line to address questions.
Mm-hmm. Okay. Now, when we send the trust indenture to the trustee, say on a credit card, does a copy of that need to go to the attorney as well?
To the attorney?
Yeah, the indenture.
Is he any part of this?
No, other than he's the at-law representative of that particular company.
He ain't got nothing to do with my trust.
Okay. That's kind of what I was thinking, but I wanted to make sure. But we do send the UCC-1 filings, notices of the UCC filings and that sort of stuff, but we don't have to send the indenture.
No, I wouldn't send the indenture to the attorney, no. But the original parties had it from the beginning, right?
Yeah, they should have, yes.
Okay.
Like with the bank account, we sent it to the CFO. However, all of these other people are the ones popping up and responding, like the senior vice president of operations. And one of the letters came.
They're not interested parties. They have nothing to do with this, and I don't have anything to say to them.
Uh-huh.
My business is with the trustee.
Okay. All right. Well, I guess we'll send him a that bill and see what he does with it.
Yeah, carry out your purpose and your intent.
Okay. Do we need to send him a notice that that if he doesn't do what he's requested, that he's in breach of trust, or does he already know that?
I think he already knows that, but yeah, you could maybe remind him a little bit.
Mm-hmm. Okay.
Put it such a way, I hate to see you get breach the trust here, so we're going to give you every opportunity to do the duty as trustee. Here's a bill. Would you blah 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 do what you said?
Mm-hmm. Take care of it. Okay. Well, those are all the questions I will bother you with at this point. I appreciate your time and allowing me to address these issues.
Okay. At this detainer hearing, this fellow said 5 things. He said, my name is so-and-so, grantor beneficiary. 2, this hearing is contrary to equity. And 3, trust is a special matter. 4, as there exists no adequate remedy at law. That's a direct quote right out of CJS. And 5, I invoke the private side of equity for relief.
Very powerful.
So all these are 5 NOIs, but they were spoken on the record in open court as the speaker testifying, and speaker testifying, those are SOIs then. And now he gets bringing the notices now for the SOIs in there before the hearing date.
Mm-hmm. Now, will that come in?
All this was said in open court at the hearing, and this hearing was postponed for 2 weeks. But the important thing here is that the plaintiff's attorney was baffled and in the hallway asked 3 times what happened in there. And he was an attorney all his life, and in his career he never saw an unlawful detainer hearing get rerouted to a new trial before.
Right.
So the equitable maxim here in the court to be applied was, although it wasn't referenced by the defendant here, would be the maxim, equity will not suffer a wrong to be without a remedy.
Right.
So when seeking an equitable relief, the one who has been wronged has the stronger hand. Now, I'm reading from Wikipedia under equitable maxims.
Mm-hmm.
The stronger hand is the one that has the capacity to ask for a legal remedy or judicial relief, which is equity. In equity, this form of remedy is usually one of specific performance or an injunction, injunctive relief, which is also equitable, like a mandatory injunction to force them into performing the duty.
Right.
And these are superior remedies to those administered at common law, such as damages.
Mm-hmm.
So the big success here is in the understanding of the unlawful detainer action versus a mortgage foreclosure action completed by sale per operation at law. Detainer has to do with the separate issue from mortgage issue, being that detainer is a possession issue with a leasee to see if he has a valid lease from the previous owner. And detainer has nothing to do with the previous mortgage issue and previous owner, which has been settled by operation of law. And they're 2 separate and distinct issues, not related. And what is important to understand here is to realize the significance of what happened at the hearing and to grasp the import of what the attorney said. Quote, what happened in there? Well, what happened was just does not happen.
Well, nobody knew to express it this way before.
Yes, the fact he never saw this happen in his career as an attorney. So what did happen? Now this ties in basically what we did when we first started NTT, and we threw in 3 lines into a court on a mortgage foreclosure issue sale, and the house got pulled off the sale block. And at that particular time, we thought that it was due to the notice issue, and the sale couldn't be completed and a bona fide purchaser take free and clear because notice had been given. But no, now we know a lot better because now we understand more about equity. And so this is basically what happened in court with the first thing we tried with NTT, putting the 3 lines into the court expressing the trust, and it stopped the foreclosure sale. But at that time, we didn't know exactly why. We do now. It's,
right.
Quote, equity will not suffer a wrong to be without a remedy. That equitable maxim, that's equity. And that's the home of NTT.
Yep.
Now, we're still in the learning stages here. We might not be doing everything right, but I think with time, we're going to have a whole lot more powerful way of getting a relief in equity.
Mm-hmm.
Because we all thought it was admiralty sliding into equity for enforcement, but equity is where trusts live. It's been trust all along getting us in the courts, getting us hammered at the at-law side because we're trying to play at law when here they were hitting us with trust.
Right. Mm-hmm.
We didn't know what was coming down, just like this guy. What happened in there?
Yep. So the tables have turned.
Yes, because the onus of probandi shifts in a trust. Usually the moving party has the burden of proving the issue, but not under equity, under trust. It's flipped. So once you make the proof that there's a trust and you make a prima facie case for a breach, the trustee is assumed to be guilty and can't prove himself to be innocent unless he's got a record that he did the performance.
Right.
So this is where we want to be. And as you've kind of demonstrated, getting in chamber is not that hard.
Mm-hmm.
We just probably didn't say the right things. And like throwing a light switch, when you got the right switches in there and you turn them on, the light bulb goes on.
Yeah, and I think it's probably had a lot to do with the language.
Yes.
That's the reason I was asking if there is certain language that one should use inside chambers so that you're not thrown back out into at law.
Think rights and think maxims.
Rights and maxims.
Equity is there to enforce rights, and equity operates on maxims.
Mm-hmm.
And equity will not suffer a wrong to be without a remedy. So that's why you get to discuss substantive rights,
Mm-hmm.
special matters.
Well, like I say, she was very receptive to the idea when I mentioned substantive rights and special matters.
Are you on the NTT, Welcome NTT group on site?
We are with, actually under Pete, under his group
Mm-hmm.
in London or England.
Where are you from?
Springdale, Arkansas.
Oh, you're in Arkansas. Okay.
Yeah. We're kind of in the desert, as it were. We have a group, and they're very excited about what they're learning about trust. Several members of our group didn't know anything about trust until we introduced them to it, and now they're very excited. So we're hoping we can bring them along.
Well, you ought to get on to the Welcome NTT group, because that's my official NTT site or discussion.
Uh-huh. How do we get onto that group?
All right, you got a pencil there?
Yes.
Yes. I guess she's got you already.
Okay.
Very good. Oh, now is that like a...
Send you an invitation, and then
okay.
You'll get in.
Okay, very good.
Last Sunday, I was on there discussing basic stuff, NTT. I was on for about 5 hours.
Ooh. Okay, very good.
She just added you in, so.
Okay. Now, that comes via email?
Check last Sunday and go back on the Sunday and go through the chat there and read it, because some of that stuff is going to be probably applying to what you're going to be saying in court to do the trust test, because you want to test the trust. And if the trust passes the test, then you got to trust.
Mm-hmm. Okay. And one probably should test the trust before one goes before the judge, correct?
Yes, because you should have all the elements and the necessary method of formation. But if you got that, you're going to pass the test. If you got the evidence, the SOIs to prove that.
This is becoming fun.
Yeah, it could be a whole different world to going into court on the opposite side.
Exactly. Yeah.
Okay. Any other questions?
I think that does it for my questions. I'll shut up and let someone else ask a question.
Keep me posted on that site.
I will do that. Thank you very much.
Maybe we'll get together on a private call and maybe review some of this, because I'd like to see you get through that. And
well, we have another case on Tuesday. My brother will be going to court on Tuesday, and he plans to follow the same procedures that I did on Friday, requesting an in-camera hearing for special matters to express his substantive rights.
Mm-hmm.
So we'll see how that goes. It'll be a different judge. So.
Okay, interesting to see then. Yeah.
We'll definitely keep you posted.
Court? Same court area?
Beg your pardon?
Same court?
Yes. I think he has that tomorrow.
Okay. Keep me posted.
I can call you tomorrow evening and let you know how that goes. Well, thank you very much. Appreciate it.
All right. Thank you. Okay. Next caller, you're unmuted. Daniel?
Hey, good evening, Christian. How you doing? This is Dan in California.
Hi, Dan. Good.
Good. The indenture, you might have gone over this before, but if we don't necessarily want to clue in the trustee that a trust has been formed, we don't have to send them the indenture. Is that correct? Other than we can deliver the res in order to form the trust, but they don't necessarily need to see the indenture, right?
Well, I think that's, if I give you my pen, I said, well, my pen back, I actually gave you an indenture.
Oh, okay. So the indenture can be that simple as the delivery.
No, the words that I said, I want my pen back. That was specific performance, and I said I wanted my pen back.
Gotcha.
That was an indenture with specific trust res. And when I hadn't gave you the pen, that was the completion of a trust right then and there. So you had notice, you had an indenture, you just never knew it.
So parole evidence doesn't work for real estate, though, right, or for land?
On the public side, no, but on the private side, different story.
Okay. Because I was thinking the other day to possibly stop a foreclosure sale in a non-judicial state using one of these for what do they call them, foreclosure mills, or some kind of law firm that actually sells the property. Since they want to behave like trustees, then why not make them trustees through delivery and appointment, and give them send them the debt title, and make them the trustee instead of the servicer or the bank. And
you could do that.
Threaten to merge title on them. You'd probably see a sale get stopped pretty quick because those guys are all attorneys, and I'm sure their legal department would take a trust indenture and a UCC1 and a UCC3 being delivered to them under notary or certified mail pretty seriously, I'd imagine. Just like the last gentleman talking about the bank account, the trust account that he started to create. They responded to him with downright hostility. So, I don't think they appreciate getting put into a trust, which I think is hysterical. Their pain, my gain. But and just I was thinking, in order to stop a foreclosure sale, something that's a lot of people are getting on these calls and they're facing a sale, within a week or a month. Maybe shifting the trust focus onto these foreclosure mills might get some immediate results. Just to
well, when we first started, we put in a motion to vacate with the 3 lines and expression of the trust, and that sale got pulled right off the sale block.
Right, but that was only a 1 month thing until you could put in your SOI and prove and claim, right?
Yes, right. Mm-hmm.
Yeah. Well, the gentleman who was just on from Arkansas, now that letter he got back from the bank, would you consider their response as a qualified trusteeship disclaimer? Did they disclaim their duties properly, or had the trust been truly formed because of the delivery? The delivery of the res.
Yeah, I think that they have the trust res, and if they really wanted to disclaim, I think they have to give the trust res back. Okay. Otherwise, they've got trust res.
Yeah, because he was reading his response, the bank's response, and I wasn't sure if they properly disclaimed.
It's how they act, because your actions can override your words, and that's exactly what's happening here. It makes no difference what they write and tell you. What are their actions?
What would define an action that would convey a disclaimer? Like, how do you behave in a way to
Well, they're actually opposite. They're saying in one letter, they're saying by the letter that they're disclaiming and absolutely we are not going to do this. But on the other hand, by their actions, that speaks totally different. They have trust res, and they're holding it. And they're acting as a trustee, and they don't know it, or they don't want to admit it. Let's put it that way.
Oh, they know it, and they know they're in breach. So,
yes, it's up to you to enforce it, though. If you don't enforce it, they're off. They're off the hook.
Yeah.
So it doesn't make any difference what they say. How are they acting? Because if they're still holding trust res, they are liable as trustees. I don't care what they say.
Now, when we want to form a trust, and through one of the methods of formation, which delivery seems to be, that they got us on contracts, the contract aspect of formation with these mortgages. But
well, that was a mistake.
Yeah, that was a mistake. That's correct. But I'm looking at, what's the most effective way for us to form trusts. And do you think a delivery along with a notice of appointment is a good idea to just kind of a little double whammy instead of relying on delivery alone? Maybe just make
No, if I got delivery, if I got green cards and I got a notary that sent it and he put an affidavit that he put so-and-so's documents into an envelope and mailed them, then that certificate under his hand and seal, I got that as a witness, plus I got the green cards, that's a done deal.
Right. So that's the best way to send something notary, right, is a certificate of mailing done with a jurat, with a notary witnessing a third uninterested party actually placing it in the
Well,
mail?
no, not the jurat is not necessary on a notary. The jurat, the notary is issuing it under his hand and seal. It doesn't need jurated.
Oh, okay.
He's doing a certificate saying that his act or his deed that he mailed such and such documents, and he's going to give you a certificate or a certification of what he did.
I think there's something out here in California that says a notary can't act on his own. I can't remember what the code is. California Government Code something 8400 or something like that. It says a notary can't. Correct. I can't remember what it exactly says, but California's got a lot of notary laws, and what I've been doing, I'm a notary, and I've just been getting my brother or a friend to actually place things in the mail, and I'm doing a jurat and attesting to me witnessing a third disinterested party doing a certificate of mailing for someone else, which in California it seems.
That might be okay, but really, I think the notary can do it under his hand and seal, and he's like certifying what he did, because he has that capacity to do that.
Yeah, I think there's something in California that casts doubt upon an action like that. I'm not exactly sure. I'll have to double check that, but just to be safe, I've just been involving a third person as a mailer, as a third disinterested party, basically. But anyways, you were speaking about that gentleman in court that raised those 5 issues of equity at that unlawful detainer hearing, and
right.
I'm actually going to court with a lady who I've been kind of helping out. We did some debt vows under 9-210 or the UCC debt validation. And now One West Bank is coming in to try to lift her stay. She just filed bankruptcy, and they rushed in 3 weeks after they got her petition to come in and lift a stay. And
how did she file? Did she file as unsecured?
Yeah. She had an attorney do it, and the mortgage.
Oh, well, then they didn't do it that way then.
Yeah, I know.
Mortgage? It's a mortgage foreclosure?
It's a mortgage foreclosure, and unfortunately, Carlos's information got to me after the fact. She had already filed her petition through a lawyer, and the property is on the secured schedule. And but either case, it's a bankruptcy court, and we filed a timely objection to the movement's motion for relief. And I wrote it for her. Well, I helped her write it, and we invoked mandatory injunctive relief. I put a few well-placed equity maxims in here, and also invoked equity because equity jurisprudence, I believe it's in Pomeroy's book, that says justice could never be attained at law in those cases where the principal facts to be proved by one party are confined to the knowledge of the other party. It becomes necessary for the party wanting such evidence to resort to the extraordinary powers of equity. So, kind of the what we're trying to create here is, hey, the financial institutions have all the evidence, and we can't receive an at-law remedy simply because of that fact, and we're invoking equity because all the evidence is stacked unfairly in the other party's hands. So,
right.
So what happened was that this hearing was actually scheduled for last Tuesday, and we were there ready to contest this thing. And the moving party, the attorney, was on a teleconference from Seattle, and he put his paralegal on the phone. Made up some cockamamie excuse that he's busy with other teleconference calls, and pretty much canceled just bowed out of the hearing. And I thought that was pretty interesting because I haven't seen a lawyer do that yet. They're terrified of these judges, and they're very respectful of the judge's time. and this guy actually kept delaying, and the judge put our case to the very end. And at the very end, after a short recess, this attorney's paralegal gets on the conference call, apologizes profusely to the judge, and then asks if the hearing can be reset at a later time. So my guess was, since we invoked equity and we did it convincingly, this attorney probably didn't want to. He wasn't prepared and just kind of blew this thing off, because there's no other reason why you stand up a judge like that and cancel. So
you object in opposition?
What's that?
Did you object in opposition?
Yeah. We objected to because as soon as the attorney put in his motion for relief from stay, we jumped on this letter and filed it right away.
I mean the objection to postponing the hearing.
Oh yeah, we did object because I couldn't speak. I was standing at the podium next to her, and I was whispering in her ear because the judge wouldn't allow me to speak. And so after that attorney virtually flaked. I mean, the guy just flat out flaked. So I nudged her and I said, ask the judge if he's forfeited his right to proceed with this action. And
I mean, he didn't bring action forward. So what?
Exactly.
You could have objected then and said, hey, we're heard for a hearing.
Well, exactly. I mean, from what I understand, the first guy to leave the battlefield loses. This guy didn't even show up. So I figured we had every right to have this thing, dismissed. So, and I told her to ask the judge that, and he said, well, no, the attorney was he called in, and as a courtesy to him, we're going to let him reschedule. And I nudged her again, and I said, ask the judge if he would have extended you the same courtesy. As a defendant or a debtor, and he didn't really like that question. He kind of got pissed. So we just let him reschedule for a week, and so tomorrow we're going there 10 o'clock in the morning. And
why don't you amend the filings and list them as non-secured?
Yeah. I'm not familiar with the bankruptcy code well, and I don't know how to do that. Is that as simple as just refiling the schedules and then starting the thing all over again, or do you need to withdraw your current bankruptcy and terminate it and start over as a pro se? I'm not sure.
Well, no, I don't think you have to. I would think we'd just have to do an amendment to the application and change it around from secured to unsecured.
Right. Yeah, because I'm well aware of Carlos's strategy. I just don't understand civil or bankruptcy procedure well enough to amend something like that. I'm not sure how to do that.
Well, it shouldn't be that hard. It's pretty well laid out, and I don't know what number it falls under, but just have to do some reading in there and catch up where it's laid out.
Right. Well, the problem with this particular woman is she kind of needed my help way late in the game. She doesn't understand trust. Don't really have the time, to go there. I'm trying to defend this pretty much from an outlaw thing, but we're trying to use the public side of equity to kind of at least postpone this stuff till she gets up to speed and is able to express a trust.
Well, I would check into re-amending them and listing them as unsecured, because that just changes the whole ball game around.
Right. No, it's a good strategy. I like it. And if you can get the bankruptcy to continue on and keep extending it, and you can get the mortgage company to be afraid enough not to try to bring a claim in court, then you can probably hang tight in your home for quite a while until you get up to speed on the trust knowledge. So it's pretty much all we're trying to do is just buy enough time to get her educated, and then after that, be a different story. So
yeah, is Mears involved in this case?
Oh yeah, of course. MERS is all over California. It's a MERS and a IndyMac scenario where IndyMac is now gone, and FDIC came in as a receiver, and now OneWest has allegedly taken over all of IndyMac's assets. But you know.
Well, you could probably win that case just on straight litigation alone.
Right. That's pretty much what we're trying to do here. If we can get this motion denied, maybe she can bring in an adversarial proceeding in bankruptcy and try to come after him that way.
In fact, I think that's what you probably should be doing, coming at them with an adversarial proceeding to make them claim up that they have the B-10. And I don't think that's the only way you can do that.
Yeah. We're just, because this all came last minute, didn't really have time to type up a complaint for an adversarial proceeding. But if we can just get a little break here and see if we can get these guys their motion dismissed for lack of standing. Something just came down from the Eastern District in California where a judge just wrote an opinion that MERS has no standing. So we put a copy of that opinion into the evidence as an exhibit for judicial notice, and hopefully he'll look at what his colleague has done in the Sacramento area and take notice of that, and see if we can get MERS knocked off that way. As a entity that doesn't have a beneficial interest to assign in the first place, and they did an assignment of her deed of trust literally 2 days before they filed their motion for relief from stay. So lo and behold, magically an assignment appears just like that. So I guess it's legal to fabricate evidence on an as-needed basis.
Yes, because the truth of the matter is only examined at trial, not before. So they can lie like dogs up until the trial.
So it's only a fraud upon the court at trial?
Yes, because that's the only time that everything is undersworn. You know, they got.
Oh, well, that's interesting. I didn't know that.
Yeah.
Wow.
Is there pleadings sworn to?
I'm sorry, Christian, what was that?
Are there pleadings sworn to?
Nope.
Nope.
Nothing sworn to.
Is there a statement in there that says they're the owner and holder of the note?
No.
There isn't?
Well, they're claiming they own the note, but they haven't sworn to it.
Okay, yeah, that's my fact. That's my point. They didn't swear to that, so they're lying.
Well,
an unsworn complaint. Now, what's the attachments attached to it? Copies?
Of course, all copies, photocopies.
Any of them got any recordings on the tops and the bottoms, right out of the county recorders or something? Especially the security agreement?
Yeah, the deed of trust is a photocopy with the actual county recorder stamp on it.
Okay, that's a copy of a copy. That is not admissible as evidence.
Right, and nothing that comes out of that lawyer's mouth is admissible. So basically, I told her to whatever comes out of that voice box, that teleconference thing, I said object to everything that comes out of that thing, because it's all hearsay. That guy has no right to speak about anything.
You got a motion to dismiss in there?
No. Is that something I should get in there?
Yeah, because really they have an unverified complaint that's unsworn, that they're not a sworn statement that they are the owner and holder of the note, or with enforcement rights. There's an attachment there of a contract that's a copy of a copy out of a county recorder. Can't be evidence. There's probably a copy of the note, which, again, has to be a copy of an original. That's unproven also. Now, is there any affidavits attached to that verifies that those are original?
No.
Probably not. So the whole complaint is unsubstantiated and should be dismissed.
Can she put in a motion verbally at the podium?
Yes, but she has to make these points, these issues, bring them out.
Right. But it is okay to move the court verbally as opposed to a written motion.
Yeah, you can, but you know, written's better.
Right. Okay. All right. Well, we'll see what happens. We can always come back under trust at a later time, but you know, she didn't even get to enjoy a couple months of peace and quiet and bankruptcy. They came in to lift this thing right away. So.
Well, yeah, that's normal.
Yeah. Well, I've been in bankruptcy.
If you list as being secured on your forms and you file, within the first 30 days, they're going to put in a motion to lift the stay. Automatic.
Yeah, it just depends on who you're dealing with. Some of these guys are really aggressive. Some of them aren't. I've got city mortgage. I've been in bankruptcy for almost 6 months, and I haven't heard a peep out of anybody. Nobody's trying to lift anything. So I guess it just depends.
That's unusual.
Well, I've barraged them.
They must be bogged down.
I beat them over the head pretty good over the last year and a half. I've got a lot of documents I've sent them, so maybe they just don't feel like dealing with me at the moment.
I mean, come in with I don't know, bankruptcy is a little different, but make the trustee point out the fact that they don't have any substantiated claims. There's no affidavit there swearing to anything. There's no sworn pleading. There's no evidence that's attached. They have no case.
Right.
Have the trustee dismiss it.
I don't think the trustee shows up to these things. You mean the U.S. bankruptcy trustee?
You're in bankruptcy, right?
Yeah, but I don't think the trustees show up to the hearings. Is that going to be a separate issue? We need to contact the trustee separately, right?
Yeah, get the trustee to act on this one.
Right. Well, the trustee got a copy of the objection to the movement's motion for relief. So I'm not sure if that helps. Or
if MERS is involved in this one and it's a federal bankruptcy case, this is a slam dunk win.
Right. That's what I figured. I'm just not not really up on my litigation. I'm learning it, but I'm not really there yet. So.
Well, somebody could guide you through that's been there before. Then that makes it a whole lot easier.
Yeah. I'm trying to, I'm following along with you, learning the trust stuff, and also trying to learn how to litigate something at law, and at least be able to comply with federal rules of civil procedure properly, and not get thrown out of there. So, because it looks like we need to learn how to do both, equity and at law at certain times, right?
Yeah, at law enough to jam them up and make it stop, but really operate in equity.
Yeah. Cool. Well, that's pretty much all I had. I'll let somebody else get on, but thanks for your input, Christian.
Are you in the Skype group, Dan?
No, I'm not, but I'd really love to join.
Is your Skype name up on the board?
Not on your. I just started the account.
All right, write this down. Contact Faith to Trust.
I'm sorry, what was that? I missed that.
Faith to Trust, and the 2 is a number 2. Faith, number 2, Trust.
Is that space?
Faith, F-A-I-T-H.
F-A-I-T-H. And then the number 2?
The number 2, Trust.
Trust. And that's on Skype?
Skype, yes. And she'll plug you into the group.
Oh, okay. Great. Appreciate that. I thought you guys left without me.
Oh, no.
Cool. Well, I I will do that right away. And thanks for all your help.
Okay, Dan. Appreciate it. Thank you.
Here.
Eric, you're unmuted.
Hey, Christian.
Hey, Eric.
Hey, in listening tonight, there was a few things that I caught that I wanted to find out about. But there was also a couple things I've been researching lately, and maybe not only for me but for everybody. I've been doing a little bit of reading out of American jurisprudence as well as corpus juris secundum, and what is the difference in the application of those two?
Which two again?
American jurisprudence and CJS.
They're very similar.
Okay, so in terms of what we might find out of both of them, in terms of the foundations that we're after, both of them might be one might be just as effective as the other.
Yeah, I find they're very overlapping, yes.
Okay. So if you're going to spend your money on a set of books, which one would you spend your money on?
Both.
Both? Okay. I was thinking about some of these cases that some of these people have been talking about tonight, and the debt, whether it be mortgage or a credit card or whatever, seems to keep coming up again and again and again. And in order to take NTT and also the more common approach of litigation in responding to a complaint that somebody might receive, and when we think about what the normal first response is, and that would be a response to compelled discovery. First of all, is that the right thinking, that would be the best way to answer to begin with?
Yes. I would get discovery going as about as quick as I could.
Okay. And as soon as you get discovery going, that's gonna put a big obstacle for them to get over, especially with the kind of stuff that we're going to ask for, which they know they're not going to want to produce, or they can't, which is just going to slow things down dramatically in order for us to create our records and get our NOI in there, right?
Yeah, first of all, if you've got discovery going on, they can't get a summary judgment on you. Summary judgment is not appropriate where discovery is in place.
And I think that's one of the biggest things that people run into when it comes to receiving a complaint, for example, in terms of a foreclosure, is knowing exactly what to do first. So that's why I was asking that question, because I think a lot of people freeze in that moment.
Yeah, and when you freeze, that's the worst thing you can do, because if you do nothing, this stuff hits you and you're dead. So
right,
that's the worst thing you can do.
And then if we employ discovery to buy ourselves some time, and it sounds like we can buy quite a bit, and possibly even just win on straight litigation with discovery, but we're also eager to employ NTT. In the normal trial schedule, or the normal procedure schedule, there's going to be another hearing coming up somewhere along the way before it goes to trial. And at that point, if we compel discovery and they fail to produce, would that be a good opportunity to introduce an NOI in order to employ NTT?
Yeah, you could, but you could probably just win that one. Just if they didn't produce, then which they really can't, somewhat on, you're going to end up winning just on litigation. So we had one case we won recently that had gone on for 17 months. And we had 5 discovery requests, and they didn't respond to any of them. And the plaintiff walked away from the battle, and we won. So
go ahead.
It's just, you've got a scalpel in your hands, you just don't know how to use it. You can do discovery and just with litigation, you can just win. With today, the way the attitude of the courts are today, and the facts that mirrors involved in a lot of these, you know, these are really no reason why anybody should lose their home. No reason at all. Not even using NTT.
Which I agree with, but based on what you were talking about recently about how somebody had a win with 5 simple statements where they closed the case down, of course that makes us all very eager to employ NTT. And a hearing following, I guess, and would there be an initial hearing after the complaint? And then we compel discovery. If we compel discovery, is there even going to be hearing on the docket, or will they just not even schedule anything until some discovery comes in?
Well, if I was going to employ NTT, I would have everything in place before I was going to be in court. And the only time I'd be in court was to show up there and state for the record that I was the grantor, in fact, and I want to know, did the trustee do his duty? Because if he didn't, day for enforcement on a breach. Now that's me. I don't know about anybody else. Most people are up to speed about to where that fellow first on the call tonight was that, you know, he's in court, you know, he's trying something new, he's not quite sure what he's doing yet, it might not be quite clear to him. And we're right at the front edge of all this anyway, that we're still working on things and getting them sorted out as to how equity is really working. Because I don't know anybody in the country that is talking about equity like we're talking about equity. And I don't know anybody in the country that's talking about trust like we're talking about trust with NTT. We are so cutting edge that everybody's got to realize that in the last 9 months NTT came out, we don't have that 20, 30 years like debtor creditors had. And some of the stuff we are doing, folks, just does not exist yet. Or we want to be sure before we give it to you that we're doing the right thing. That's where we're at today. We're like on a surfboard riding a wave on Maui Beach, or Waikiki, or wherever it is out there that they surf on.
The North Shore.
Yeah.
But in going back to my question, just to give people that hear this, that are listening now and might hear this in the future on a recording, as far as the normal process, as far as the way they schedule hearings, really what I'm getting at is there's going to be the complaint and then the answer, which is going to be discovery to that complaint. And then just like every normal process that where there's a complaint filed, in some time in the future, there's going to be a hearing. And what I'm getting at is at that hearing, that's a great opportunity to not only bring up the fact that the complaining party has not done anything to prove up their claim, but also to introduce your NOI and state your SOI right on the record.
Yeah, well, NTT is so radically different, so 180 degrees opposite of what everybody is so used to that they can't see how powerful it really is. And these little examples we had here, these little successes here, you've got to realize the import of what that attorney was saying when he said he never saw in the history of his life being an attorney a trust or a detainer hearing get rerouted to a new trial before. These guys absolutely know nothing about equity, other than they put, this is an equitable hearing, a mortgage foreclosure and equity. I doubt very seriously even if they know what that means. They're so used to working at law, and at law is the only place they can work. You get into chambers and you're the 900-pound gorilla. And you've got to realize that that's the strength that you've got. Under a trust in equity. It's flip-flopped. It's not like what you're used to seeing in a court where the judge is going to hammer you. You come under NTT under a trust in an in-camera hearing, or even in chambers like what these two fellows were talking about here. The attitude of the judge is, how can I help you, please? Totally different. Because you're in a different law venue. You're getting hammered at law by a trust that's being enforced in equity and don't know it. Now you come into equity under a trust and you're the one swinging the hammer. We're starting to see it. We've been going on the wrong path for 30 plus years. Under a debtor creditor, under a general deposit, and we need to be coming in specially and reversing those general deposits to special. And it's been there all along, just never could see it. And I don't understand how some of these other leaders in the groups have never seen this before.
Well, Christian, it makes perfect sense to how powerful this is, because I think it was on Welcome NTT chat recently that somebody was posting some quotes from the Bible about how the law of the Holy Spirit is inequity.
Yes, right. Part of it.
And of course, when we use non-precatory language, we order, command, and direct, and well, the Holy Spirit gave us the 10 Commandments. So why wouldn't we think that this is going to work?
Well, because we've been so used to the debtor-creditor at-law side where we get all the time that we think that the judges say they don't do what they're supposed to, but we're not under that law form. If we come in under equity, we're in a different law form. Different set of rules. It's a different ball game. And that's what you've got to realize.
Now, I wanted to bring up something about what you were reading out of CJS tonight, about it's the court's discretion whether or not the trustee has to provide a bond. And when I was listening to that, I was thinking about the grantor privately could provide some type of requirement for the trustee to perform. But is the bond required by the court only required in the public, in the at-law side? Is that the only place where that's applicable?
To tell you the truth, I think it should be done the opposite. We should be indemnifying them against any harm. Not getting a bond, getting them to get a bond. We should be granting a bond or indemnifying them. We should be granting indemnification to them. We're the only ones that can. Let's protect them.
And that wouldn't matter whether that's a judge or a CFO at a bank or whoever it is that we have the records.
If I stand behind and say to you, anything that you do, I will stand good for if any damages, anything goes wrong, as long as it's legal, then what fear have you got to do something for me? I don't need a statutory bond.
So in reference to what you're reading out of CJS, if the court were to require that the trustee be bonded, would that only apply in the at-law side?
Yes, but that's all at-law statutory black stuff anyway.
Yeah, I was just, when I was listening, I just wanted to make the distinction as to when the court can actually require that.
By statute, or if it was in the indenture.
Okay. And the indenture could be either at law or in the private, depending on which side the trust is.
If that's statutory, it's in the statutes, that's obviously a statutory trust, which is a public trust. That's a black trust.
And the grantor could require that as well, in addition to the statutory requirements.
Yeah. But then again, that sounds like a black statutory trust, even if the grantor was requesting it in the indenture then. How else would the indenture be known in the public unless it was a public trust? I really don't want to work with public trusts. I think I'd rather stay on the private side. Although I'm going to control the public side by knowing about what's happening there, and I'm going to control it by staying out of there. Equity controls the public side anyway. Probably going to find out in these in-camera hearings, these attorneys can't say anything. The judge's going to shut them up. And I've heard some things on that already. Still there? I lost him. Let's see if he comes back on. Maybe he's dialed back. Not coming back on? Okay, let's go to the next one then. John, you're unmuted.
I just about went to sleep sitting here. I've got an IRS situation, and listening to Jeff the other night, he said that the IRS agent had filed a lien against him and he had signed it. I've got 2 liens actually, but the person that signed them is kind of a fictitious person. But the agent, I've had contact with him on several different occasions. If I appoint him trustee, will he have to notify me that he's not going to be the trustee, or?
Well, that's about the only way he can disclaim.
Okay. So if I send him a notice.
A notice of what?
That I'm appointing him trustee.
Okay.
And send him the liens and sign them across the face of it, diagonally, and then sign it on the back. Now, that's what I had in mind. And then go ahead and do the UCC 1s and the 3s, get that part done. The guy that was on earlier from Arkansas, I'm one of the people that he has helped a bunch.
Okay.
So I'm at a loss. What I first started out to do was I was going to set up. Let me get it up here.
Are you in Welcome NTT group on Skype?
Well, I can't do Skype because I can't type.
Oh.
So it's almost impossible for me to communicate. My wife types some, but she's not up to speed. But what I was going to use was Allison Doon. She's the CFO of the Technical Support Division. But after listening to Jeff the other night, it seemed like to me that would be a whole lot more logical for me to use him because I'm in bankruptcy too to stave off the IRS. And that other one that was talking about the bankruptcy, you can go back and amend that that form where you put the creditors in there. You could amend that anytime you want to.
That's what I thought. Yeah, I thought it was a lot simpler than what.
Yeah, I went back and amended mine because it's kind of a crazy thing. You go on the internet and you fill out these papers, and I put them down as unsecured, but there's no signature place on that one, and then you have to fill one out on a paper form and present that to the court. And so when I did that, I did a stupid thing, and I didn't put unsecured on the heading. So I just went back and added another creditor and redone it all and turned that. And I had an attorney, and I know what he's going through. You know, the attorney, he's got his way of doing things, and that's the way it's going to be. But I just told him, no, I want you to amend that because I goofed it up. But to get back to my point, I don't know. But I suppose, well, I guess what the question I'm asking is, how much time do you think he would respond right away quick? He probably would have to, wouldn't he? Respond pretty quick if he was going to reject the appointment?
You could put a disclaimer in there and give him so many days if you wanted to.
Okay.
No, I would think that at least commercially it would be 72 hours.
Okay. Well, I don't have a time in the actual constructive notice. I was going to send that to him, and then see, I haven't done the UCC ones or anything. I'm set up with our Secretary of State here that I can do it over the internet, and I could probably get that done possibly in one day, 2 at the most.
Well, see, the UCCs are not actually the real thing that's going to be the evidence that you're looking for. It's the documentations, like it's the actual delivery that forms the trust. So whatever the trust res is going to be, it has to be delivered to the trustee, and that's the time that the trust forms. Then we'll go and do the UCCs.
Well, that's what I'm saying is I'm going to deliver these liens to him with the notice. Now, isn't that proper? I mean, isn't that doesn't that establish the trust res?
Yeah, that's if that's your trust res, that you're going to be the liens would be the debt title, and then you would merge them with the equitable asset title that you would put over it, and then give it back to them merged as trust res.
Okay. Would I write across the top of a special deposit?
Yeah, you have to write on there somewhere, or else put an additional sheet with it as a special deposit order.
Well, now in the okay. Okay, now I'm confused again. I was going to send them with the notice, and then I was going to follow that up with the indenture. If he didn't respond in the adequate time, I was going to send the liens.
Well, see, I would send the trust res with the indenture and instructions, the special deposit, send it all at once.
Oh, okay.
And I would make the records by the green cards. I got a signature that he's received it. Now I know for a fact he's received it. That's my private document. Then I would send the copies of the UCCs later on after I did the UCC filings.
Okay. And you think if I don't hear back from him in 5-6 days, then I can just go ahead with the the whole process. I mean, that was my biggest concern. I didn't know what to do on the UCC ones because I didn't know who I was going to send these to.
Well, you can make anybody you want the trustee. It's just like the fellow there with that first one on the call tonight. He went over the court case there. They got the letter back from the bank. You know, it wasn't that what the letter says, we disclaim, we refuse, we're not absolutely going to do this, you know. What is it they were actually doing?
Well,
no matter what they said, forget about what they said. What are they actually doing? Because their actions override what they say. And how they're acting, well, they've got trust res. And they're sitting there using this account. So they must be the trustee. They must have accepted.
Well, the other thing that
despite the fact that they wrote a nasty letter and said, "Hey, we don't want to accept this." Your actions.
The other thing.
Words.
Okay, the one thing that I noticed about it, I didn't think the president responded back, or the CFO, or whoever. That they was getting this from other individuals, which didn't mean much either, because they wasn't a party to it. To what. You know.
Yeah. Anybody's not a party doesn't have to be responded to. It doesn't really.
Right. Okay. Now on this lien, I should just write across the top special deposit and then sign it with my Social Security number across the face of it, and then turn it over and endorse it on the back.
Yeah, you've seen that special deposit. It looks like a check that we had.
Uh-huh. Well, I think I have. Okay. What else have I got here? Now, the only thing that I didn't do, I haven't got a green card back from the SS5. I just sent it, but I didn't send it. Well, I did send it with.
That's really not too necessary for this because you could prove a trust by claiming this liens as being trust res and form a trust just out of that, and really doesn't have to have so much to do with the Social Security, SS5, and all that.
Well, I mean, I've got it, but I don't have the green card. That's what I don't have. So you don't think that's that important either, huh?
No, not really. No, it'd be a green card on the trust res that you sent to the trustee. That would be the important one. And as long as I had the elements of intent, purpose, parties, specific trust res, and one of the methods of formation, that one being, say, delivery, with the green card being approved. When I did the UCC 1s and the 3s, withdrawing and then redepositing a special, and then on the indenture expression of the trust, and executing the trust, then I've got, you know, what I need to extinguish the debt and prove it.
Okay. And I should send all of this registered mail, right? Okay. Well, okay. I believe that's all the questions I've got now. I'll probably think of more when as soon as I get off. But I think the boys down Springdale can help me if I don't have everything exactly right. So. I appreciate you much. You're doing a great job, and hopefully we'll get this thing, we'll get this country back again, hopefully.
Yeah, one mortgage at a time.
One mortgage. Well, this is, well, I guess this is a mortgage. They've got me out on a limb for about $250,000 is what they're paying.
They got you mortgaged, yeah. They got you mortgaged. Yeah. Yeah.
It's a hefty one. So
just claim it as being special now and reverse it, withdraw it and reverse it.
Okay, now go over that again so I make sure I've got that straight.
Well, you want to take that out of general deposit and withdraw it, and then you want to redeposit it as special, which is really the same thing said a different way, merging titles. You know, you're merging, extinguishing the debt. It's the same
now, do
thing.
I do that in the indenture? No.
Well,
I've got this. Well, I don't know exactly where I did get it, but
you got access to the audios, the past audios?
yes.
Okay, look on the one that's talking about the general versus special, or general deposit nature of deposits. I forget what date that is, but that is showing how we do a withdrawal and redeposit a special. That audio explains that.
Well, I think this is what I've got. This is a re-entry by the grantor settler whose exigent circumstances expresses his intent to grant the equitable assets of the original segregated special trust res, and then I've got in there my Social Security account number. Is that right? Deposit.
It says it's 5/8 is the tape. 5/8, 2010.
I didn't get that.
5/8 is the date of the tape, the audio tape.
5/8, okay. And that's 2010?
Yes, 2010, yeah.
Okay.
Okay, what were you saying again on the deposit?
Okay, deposited for a specific purpose in the past, now being held by the trustee, and then I had Allison Doon in there, which I'll change, for the benefit of the beneficiary, and then my name as the account beneficiary to be returned on grantor settler's orders at a future time, along with all trust res, principal, and interest. And then the undersigned herein and after is grantor settler of this confidential relations expressed revocable private trust modifiable from time to time in confidence with age of majority and the power to choose and have all available rights, titles, and interests without granting or waiving any rights, remedies, or defense, now comes in good faith under 1776 AD law form with purpose of all laws of nature and nature's God specifically instructs, specially orders the following within 14 calendar days of receipt. And then, grantor, number one, grantor hereby orders that all general deposits be withdrawn and redeposited as special deposit effective immediately. Convert trust res to funds appropriate to extinguish all debts. And I've got the court case in there, so now I would change that to the liens. And provide a complete accounting of all transactions and return any overage to grantor. Now that was the indenture that we come up with.
Oh, that sounds pretty good. So yeah, I think I would get the job done.
Okay, so you would just okay now. So across the top of this lien, I would just write special deposit.
You know how you make a check out to yourself?
Uh-huh.
So you signed the check, you made it out to yourself, and then you flip it over and you endorsed your name on it. And really what you did is you turned it into a bearer instrument. You could have handed that check to anybody, and anybody could cash that. Basically what you're doing is the same thing on that. You're turning that debt title into this, merging it with this equitable asset, which is this check-looking form here that you're doing. And when you endorse it on the back, we've modified it. It used to say pay to, and then it would be in blank, just like on a mortgage note that's endorsed in bearer form. But we've changed the pay to line on the back to special deposit to, and then leave that blank. And whoever's holding that instrument, that's the special deposit. Who's got it? It's in bearer form. Whoever's bearing it has it. They've got the special deposit order, and that's the payment. And when you stick it on top or on the back of this lien, you put the debt with the asset, and you merge the two, and then send it back to them as trust res, already extinguished.
Okay, I think I got that. I think. Boy, this is all so new to me, and I have been studying. I've been listening to past hours on end, as much time as I can. Well, okay, Christian, I appreciate your help. I think this has got me pretty well lined out. I'll get this thing going tomorrow and see what happens.
It's just like what I would do is I would sign a 45-degree angle and acceptance, well, not acceptance, my name across the top, and I put the date on, Social Security number and that, and then on the, like, I don't know, is there multiple pages to this?
Yeah, there's 3 total, I think.
So I'd put, like, if there's 3 pages, I'd put like 1 of 3, then the next page 2 of 3, and the next 3 of 3.
Okay.
So I got them numbered.
Okay.
And then I'd put my unique number on there, my RA number, whatever I'm going to call this thing, so I can identify that title as with that number.
Okay.
And then I'd flip it over on the back side, on, let's say, the last page, and I'd put that last endorsement on there, and then sign like an endorsement line, and then put the special deposit to, and then draw a line, leave that blank.
Okay. Okay.
So now the front part, you can make that look like a check.
Well, it's kind of hard to make it look like a check.
Just think of what's on a check. You know, you got the date, you got the amount line, and you got the pay to line, but that would be your name going in there, and then you got the signature line, and you would sign your name in there. So really, you're signing on all front and back, but you're turning the whole thing into a bearer instrument as a special deposit, and whoever's holding the instrument got the special deposit and got paid. So if you ever saw a note that's been endorsed on a mortgage and they've got the endorsements on there, really what we're doing, we just duplicated what they did, except we just changed the terms around to, instead of be the pay to, we put special deposit to.
Okay.
We just kind of mimicked what they've done already on these mortgages when they endorsed them and securitized them and passed them on along the line. So I would put on there non-negotiable, say like, you could write that on there also. Private special deposit order.
Now down below the amounts here, there's some open space kind of in the middle of it. I suppose I could do that there.
I don't have to have an open place. I just put it right over top of it.
Oh, just go right over the top of it. Okay.
Yep.
Okay.
Just make sure that you leave like the critical parts, like the amount line out, so they can see that.
Okay.
But then I would also be writing in the amount. I would like putting a check face of that, which I would write out the amount. You know, it's like $100,000. That's what the bill was for, $100,000. Well, I'll give them a check for $100,000 by special deposit. So in the little corner, right-hand corner, I'm going to put 100,000, and then the line I'm going to write out $100,000. And then the account number is really the Social Security number. Really, it's the trust number is, you know, the straw man all cap names, and then the Social Security number without the dashes. And that would go on the line where your routing numbers would go, say. And then sign it by trustee and my name.
You want me to sign it by trustee?
Yes.
I thought I was making him trustee.
Okay, all right, then, excuse me, we're forming a trust, excuse me, I'm wrong on that one. Grantor, excuse me, we're grantor.
Okay. Phew. I thought, boy, am I off in left field. Okay.
And if I was making a payment, I would be signing as trustee, but since this is formation of the trust, then, yeah, this would be or multiple special deposit by grantor.
Okay. Well, all right, I think I've got this pretty well nailed down here, if I can read my notes. Hope this works. I hope I get it right. I'll put it that way. I'd like to make sure that I get it right so that, you know.
Well, let me encourage you a little bit. We've had some other successes doing the same thing.
Well, that sounds good. All right. All right, Christian, I'll let somebody else get on. Appreciate you much, man.
Okay, thank you.
Mm-hmm.
Okay,
Hey,
Eric.
Christian.
Hey.
Hey, sorry, that darn Skype cut me off. Happens to the best of us. Hopefully it won't happen again this time. When we got cut off, we were just talking about the security and being required in statute, and then how we would indemnify in the private. And so if we were to indemnify in the private, would that just simply be an order in our indenture, and then from that order, that would create the indemnification, or would that be a separate document?
Yeah, we just incorporated that on our indenture.
What might some wording for that indemnification? Give us a model, some type of model of what we might want to include in an indenture for that.
Well, we just put down there two lines, really. Trustees' names, so-and-so, are fully indemnified and held harmless against all commercial losses and damages actually sustained in the execution of the lawful duties of the for the benefit of the trust.
Simple as that.
Huh?
Simple as that, huh?
Yeah.
All right. That sounds great. We're certainly going to be looking at that and maybe looking at including that in some of our indentures that we're working on now. One of the things I wanted to share with everybody, just so when they hear this, they'll have an idea of what we're all shooting for should we have to go after a party for a breach. And as we were talking about earlier, from those cases you shared with me on special deposit, we're actually looking for a decree in equity, because that's what the court will find is a decree.
And a decree is an order, so we're ordering. We want an order, and the order would be an order for mandatory injunction.
And when we have a claim brought against us, for example, in a mortgage, because of course it's the folks that think they're the beneficiary are exercising the right to take. In that context, when we flip the titles and then become the grantor and then name them the trustee, in that situation, when we go into the private and make that order, the decree would remain private, or would that be a decree that would become something in the public, or how would that show in the public?
The order would be public. The judge would issue the order, which you'd get him to sign your mandatory injunction for the public side. And the mandatory injunction would be enforced on the public side through the court. And that would order the performance of the trustee to do the duty, which was my right, that he breached.
And the way that we might come in against that claim that they make would be at first, for example, in the public with a temporary restraining order or injunction, and then go for that mandatory permanent injunction, go for that order in the private, and then get that recorded back into the public. Is that the right process of thought?
Yes, right.
Okay. Because one would not come in against their claim with a permanent injunction to begin with. You would only come in with a TRO?
Mandatory injunction is only when you win.
Okay.
So you come in with a temporary or preliminary injunction to stop everything until the case is heard, and then when you won, then the court would issue the mandatory injunction, which would force them to do the performance.
And that would be by decree, of course?
Yes.
Okay. And
for your order on the private side, but the judge is going to sign your order on the public side.
Great. And in responding to one of the things that somebody brought up earlier, when the gentleman was on the call and he was in court with someone in reference to a case, and the judge would not let him speak, and he was speaking about, he just recently learned about Carlos's information, and if you remember that gentleman, well, in cases like that where we might be assisting someone, if someone were to grant some interest in the property that they're trying to keep the other party from taking, if they were to grant, for example, it was a piece of real estate, for example, and somebody had a foreclosure action against them, and they were to grant 10% of that to me, then I would have every right to speak at that point because I am protecting my interest at that point, and then that way the judge couldn't say that I can't speak at that point, correct?
Yeah, he couldn't because he actually got some kind of interest. But remember, we're reading in corpus juris on statutory side, any interested party, and that could be anybody who's really on behalf of, say, the beneficiary, can make a claim. Now, I don't know how we want to maybe try that, but the way I'm kind of taking that is that just about anybody could step in for somebody else. But I would rather have some kind of interest, because now I can't be accused of, say, working on behalf of somebody because I've got an interest in it myself.
And when you have the records to show interest, then there's just no way that they're going to try to shut you down.
And they can't.
Yeah.
Got an interest.
That's it right there. Okay. Well, hopefully that answers everybody's question as far as being able to help folks out that are not so familiar with this process. One of the things that you mentioned earlier, and I didn't catch it real clear, but you were talking about MERS and how they have no standing and how somebody has to come in, and I think you said claim up, and I think it was the B10. Was that the right term?
Yeah, the B10 is the
what is it?
The proof of claim form, the B10 on bankruptcy. Yeah.
Okay. I was just trying to get a little clarification because you kind of buzzed through that quick. And going back to MERS, let's say you have a servicer that you close a loan with back onto a mortgage again. You have a servicer that you close a loan with, and let's say they keep the loan for 3 or 4 years and then they sell servicing. Now, at the point that they sell the servicing, and it was never a MERS loan before, do you know if it could become a MERS loan after it's closed several years down the road?
I don't think so. It has to be, I think, set up by MERS to start out with.
Okay.
Would be listed in your security agreement.
So if it's not MERS and they are selling the servicing, then there must be some recording system out there that keeps track of this thing. Any idea what that system?
MERS is not the only same system. Could be somebody else. You know, I mean, not MERS, but it could be acting like the same thing. Although it's not recorded in the MERS system, there's probably another system similar to it. You know, I would imagine there's other entities that have similar systems.
You're just not sure what they are right now. Maybe that's something we could research and find out.
Right, because if it's not MERS, you know, how do you track it and find out whether or not it's been securitized? Because if it's been securitized, you got the same issue as MERS. And they're really knocked out too. They're functioning just like MERS.
Because they have no standing, just like that judge recently rendered an opinion in California, and of course the Kansas City case, or the Kansas Supreme Court. I'm sorry.
Yeah, it's just one more jump you'd have to make and connect the dots. It doesn't have to be MERS. It's just the principle behind it. If it's in a recorded system and it's been securitized, the trust has separated the mortgage from the note, and they really can't foreclose. Now, that's what really is happening. I don't care what the judges are skirting around and saying, but the note's been bifurcated and separated. That's the real issue. It doesn't make any difference whether MERS is involved or some other entity. That entity is functioning like MERS, and they got the same standing as MERS, which is no standing at all.
Now I went back to 424, the recording, and the title of the recording was "What type of estate are you holding at your property?" And there was a lot of there was something key in there that you said on that recording, and one of them was that you went back to the banker's handbook, and in the banker's handbook it said that a deed of trust is also a trust receipt.
Yes.
So if we have a deed of trust, and I know Florida's not a deed of trust state, but for those out there that do they even need to go through the process of filing a UCC-1, or do they only need to do the withdrawal on the 3 and then the redeposit on the 3 as special?
There's your UCCs. There's your trust receipt.
The deed of trust, right?
It doesn't have to be a deed of trust, although a deed of trust can be a trust receipt. But if you read trust receipt in blacks, it says that it's a UCC filing. And what are you doing? A UCC filing. That's your trust receipt. That's your regular.
Well, what I'm getting at is could we avoid the step of doing the 1 since the deed of trust states already have a trust receipt in place?
Yeah, but we're using them as kind of like a dual purpose for noticing the actual act that's been done prior, and we're using it as the notice to reflect it to those facts, and that can be seen in the public. So we still need a notice in the public. Now, I sure don't want a deed of trust to be the only thing that's recorded in there and then construing it as a debtor creditor. I'm going to have to reverse it out of general and redeposit a special. So I still think we need the documents we're still doing.
Okay. Now, in line with that thinking that a deed of trust is a trust receipt, what about a mortgage in the mortgage states?
Same thing.
Okay. And moving on to something else, some people were talking earlier about when they send indentures to the trustee that's been recorded, they were talking about doing certified mail. And I know recently we were talking about that, and you said do registered because registered is private, and also it never times out.
Correct.
But do we need to be concerned about if we were to use certified? Would there be some lack of effectiveness if we were to mail it that way?
Well, certified is public. I really don't want to put my private stuff through public. Because that registered mail, that's under that's under the post office. And the post office is pre-1776, pre-United States, pre-America.
So registered mail it is.
Yeah, I would say for
And in line in the realm of the thinking about applying some of the regulations and some of the practices of the post office, I've heard that when we put a 2-cent stamp on our documents in the public, that will alert the folks, for example, the judge viewing the documents, that we're invoking a higher, and I know it's still in the commercial, but that'll alert them that we are invoking a higher form of.
That's UPU, and that's Admiralty, that's Lex Mercator, that's Commerce, that's public.
And of course, I was saying that with the idea of introducing NTT, but if we were to do that, for example, on our documents to compel discovery in litigation, is that something you might do? Or is there just no sense in it as far as you're concerned?
No, I don't think I have to do that.
Okay.
I think I'm muddying the water and with debtor creditor stuff.
The only other thing I have to say is I'm going to strongly suggest that everybody go back and listen to 424. What type of a state are you holding the first 20 minutes of that recording? I think it's consistent with the 5 statements that Christian mentioned earlier about what we do to invoke equity and discuss that there's not a remedy at law. So we really know how to present ourselves, because there's some really key stuff on there. And with that, I'm good, Christian. I don't have anything else.
Okay. All right. Thanks, Eric.
Thank you.
Hey, Anonymous, you're unmuted.
Oh, hi, CW. This is Rick from California. How you doing?
Hi, Rick.
Good. Well, it's some great call tonight. A lot of good stuff out there, and a lot of questions came up for me just for clarification points, so most of my questions will just hopefully be short and sweet. I heard you mention something with his last caller about he's trying to help someone in taking an interest and giving the person who's in foreclosure, giving the person who's helping them an interest. Could you clarify that? Because I had a call come in and I wasn't able to grab that whole thing. Is that something that's doable? Is that what the bottom line was, that if someone is in foreclosure?
He's granting them like a 10% interest.
Right.
Yeah, and then when that fellow has an interest, then you can speak.
Speak for his, okay, so that was a doable. Okay, all right, next thing was you mentioned something about BK with an earlier caller and how to put a how the I think Schedule F mortgage is unsecured debt. And I mentioned that to a few people and got some real pushback on that, because they said that becomes adversarial, and that BK court is not an adversarial type court.
Oh, yes, it is. It is.
Okay. So that they're mistaken, and you can do that, and you can force them to prove claim that they own the note or have an interest in the note in order to foreclose.
Yep. Mm-hmm.
Okay. All right, good. And then next question, this is from last night. It was really good Sunday night. You guys, it was a great chat on Skype, but I just wanted to clarify some things again. When you invoke trust to pay off your mortgage or your car or credit card, it does not take you totally out of debtor creditor. Is that correct?
No, it doesn't.
Okay.
And I'm really not paying it with I'm merging the titles.
Right. You're merging the titles, which is a trust, is it not?
Yeah, but I don't like to refer to. I'm making a payment out of a trust. Really, that's
okay.
Not really what we're doing. We're merging titles as extinguishment of the debt.
Okay. Then the other question didn't get answered last night was, and this is the IRS one. I know a gentleman earlier was talking about his own IRS issues. My understanding or debt, and try to get those out of there, you're stating to the IRS, a person would be stating to the IRS that they're that could put them in some jeopardy?
Well, they didn't really straighten out the whole record. If you did, you'd put the whole thing in jeopardy again by doing the debtor creditor stuff, yes. But if you're just like doing one issue or one case or something, then, you know, that's a different story.
All right, so if a person, like, say, suppose we had a federal tax lien and had like 3 years worth of debt, you know, like we'll say, you know, just pick a year, 06, 07, 08 or whatever, and they had to get that taken care of. If they merged those titles and sent that in, that would not take them out of debtor creditor or keep them from earning money to stay out of trouble or anything of that nature. Is that kind of what we're talking about?
No, it's just like they closed that one issue down, but they're still working in commerce and under debtor creditor.
All right, so as long as they're individual issues, that a person shouldn't have any real major concerns.
When you try to get out, and then you do the debtor creditor thing again, then you just put everything that you did in jeopardy.
Right. When you say get out, and my understanding by that, what I'm interpreting that to mean is that the solution that we've talked about in previous calls, whereby you take control of your master trust or something, and then you set up an LLC to write.
I've gotten rid of all the debt.
Okay, that's when you put yourself at jeopardy.
Yeah, I've terminated the account, terminated the trust, and then I turn right around and go do debtor creditor again and get right back in.
Yeah, okay, perfect. All right, so that clarifies that. That's really good. I appreciate it.
You are incompetent. You're a ward of the court. And I'll probably...
Well, I'm so incompetent on this call. I mean, there's so many good calls. I'm asking pretty basic stuff, but I appreciate your patience. Let's see here if there was something else. On the court case, if I understood correctly, and again, I'm just trying to, for clarity points, because there's so much good information, my sale date's been postponed to August 10th. So if a person's sale date's been postponed, now I'm working on generating the merging of the titles, the debt title and the equity title, if I understand correctly, from the other night. And so my goal is to get that all processed. And then how do I, at this point, force the bank to get me into court? Or, I mean, I have a separate court case that's not really tied to the foreclosure. It's a separate court case. But how do I get that information to the court before the sale date in order to present to the judge that, you know, that I have claim?
Well, what court have you got? What have you got going on in court?
Well, I've got a separate court case that's a lawsuit against the lender that's foreclosing, but that court case revolves around them RESPA and TILA violations, basically. And
same entity you're forming the trust with?
I'm sorry?
The same entity you're forming the trust with?
Well, I guess that would be the case, but I filed the lawsuit before I knew about you guys. So I guess
I'll just come in with an amended pleading, or even maybe just a motion for a hearing and put it in equity.
Okay, now if I understood what you just said, so go ahead and do all my merging of titles, then make a motion on the other case to get a hearing, and then with the judge, and then present the merged titles that I have and the two witness thing, the NOI stuff, present that to the judge on that side.
Yeah, the worst thing you'd have to do is the attorney may object because you don't have a pleading on the issue, but then go get an amend your pleading to encompass that.
Okay, even though I'm suing them, separate issue from the foreclosure, I'm suing them because of RESPA and TILA violations, which...
Right, so come in on a motion saying claim equity, and bring in the equitable stuff.
Okay, so come in on a motion to claim equity, and then bring in my merged titles.
Yeah, you could do a show cause hearing, an equitable hearing, put in a notice of a hearing, and then come in and use that as your shoe-in point for getting in the chambers.
Well, how would that, though, all right, let's assume, and again, this is where there's some ambiguity for me. Again, I'm about 2 weeks into your lessons here.
A lot to learn, yeah.
Yeah, I know. You've been doing it a lot longer than me, so I'm dancing as fast as I can and trying to make a living and everything else like everybody else, I guess. So let's say I get the motion in, I can show that we've merged titles. At that point, does the lender have to reconvey, or are they going to fight that all the way? Do they have to reconvey a clear title to me? Or am I just taking possession of it on my own because I've demonstrated that I have the claim?
Well, if your equitable asset extinguished the debt, made a payment, in other words.
Right.
Don't you normally get a reconveyance?
Yeah, but that doesn't mean they have to act in honor. I mean,
release of lien, that's what you get.
Release of lien. Yeah, but it doesn't mean that they're going to act in honor. I mean, that's what part of all this mess that we're all in is.
Yeah, but see, what your problem is, like everybody else, is you're still thinking at law.
Okay.
And not equity.
All right, fair enough.
Yeah, they may do that, but the judge is now on your side.
He has to be on my side. But what if he acts in there's no way he's going to act in dishonor. He's not going to, make a big scene or say, I can't do this.
I think these judges are not the ones at fault.
Okay.
It's us, because we're not giving them what they need to act, because we don't know what the law is, we don't know what the rules are, we don't know what the procedures are, we don't know what the process is, and we blame them. No, it's us. Look in the mirror. We are the ones.
Okay.
We're the ones that are at fault, not them.
All right. Now, I'm going to go back to, I think, the second caller tonight. He said that when he was in court in the public, across the bar, that the judge was open to seeing him in private, and the judge said, obviously anything we do or say in private can't be admitted as evidence. The word he used, if I recall correctly, was admitted as evidence in this hearing.
Right, and I don't want it admitted as evidence.
Okay. Well, if it can't be admitted as evidence, then I guess what I'm having trouble understanding, again, because I'm still old school here, is they can't admit anything in evidence, anything he shows them can't be admitted into the case, then how can the judge rule in his favor in the public? Because
he's a judge. And he's applying to the conscience of the court of equity.
Mm-hmm.
And the burden of proof is shifted.
Mm-hmm. All right, so when you go in equity, it puts them. Okay, you get control. Okay, all right. Then it's all by faith we're taking this. I mean, I'm all new at this, and it sounds great. Another question. I've heard you mention a couple times tonight that you've had some good successes. When you mention good successes, when it comes to the mortgages and so forth, are you suggesting that the successes are people who have gotten their house free and clear and the lien removed? Is that what you're indicating?
When we first started out, we had a foreclosure sale on the sale block, knocked off the sale block.
Okay.
So we've had other people with IRS bills zeroed out.
Okay.
We've had other things with banks zeroed out.
Mm-hmm.
We don't have a whole slew of stuff. It's only 9 months old.
No, I'm not making a judgment. I'm just asking, like, I know you don't like to, make a big claim about everything's going to work.
We haven't got to the point yet where we got a reconveyance of somebody's house that was sold, say. Not that I know of.
Okay. All right. Well, that's fair. I just asking.
I think it's premature to tout the successes at this point.
Right. And I appreciate that because a lot of people would be doing just the opposite and not giving.
Although a lot of people are criticizing because we're saying we don't have any successes. Well, I don't really care. It's the principle I'm operating on.
Right, right. Well, if the principle works, then
that kind of attitude, Columbus would have never discovered America, or Edison would have never discovered the light bulb.
Right.
If Edison had to rely on somebody's success to make a light bulb,
right,
we're at a standstill.
Right, we're still in the fires on poles. Another question on the second caller, I believe it was. He was mentioning about how he made the bank the trustee, and they told him in a letter that they did not accept that role, basically, and he had to close out the account. Now,
yes.
Is that without giving a little history on that, would that have been considered a way, is that the account that he opened, is that one of those accounts that you don't give your Social Security number out? It's a private account, and is that why they were acting that way? I mean, I didn't hear a lot of background on that.
I think that was a general checking account or some kind of general account, and
right.
he just switched it from general to special.
Right. Okay,
but
so by doing...
If they had control of that account, then why didn't they close it?
Exactly. Yeah, they try to intimidate you into doing what they want you to do. Yeah. Okay. Okay, that's my questions for tonight. I appreciate it very much, and again, keep up the good work, and look forward to learning more and more. Appreciate you. Thank you.
Okay, Rick. Thanks. Okay, one more. 612.
Hey, CW, it's Keith. How are you doing?
Hi. Okay, Keith, how are you?
Good, good. Yeah, I'm the guy that overcame the unlawful detainer for my buddy.
Uh-huh.
And I had told you, made the comment that I think you should change the name to Split Personality Trust Technology.
Yeah.
Well, what happened was, just for a little recap, actually, you know what? I'm going to tell a story after I ask this quick question. When you talk about merged titles, by definition, we could be talking the nuance of a couple different things. One, I can appreciate putting an asset equitable, title on top of a debt offer, a public debt offer, and that by definition is merging a title. But isn't another form of title where you basically sign grantor beneficiary and then endorse your beneficial title to the trust? Doesn't that also terminate the trust?
That's kind of like making a payment from the trust. Yeah,
like if the bank sends you a renewal for a credit app, and you say, okay, I'll sign your credit app, I'll sign a grantor beneficiary, and then endorse it as put an allonge with it titled like beneficial title transfer, and transfer the beneficial title to the trustee right after you sign the credit app. So you just granted credit to the beneficiary, and as the beneficiary, you just conveyed beneficial title to the trust, all in one credit app. And then say, please apply the credit to the loan to pay it off. There, you just made the payment.
Right. Yeah.
I signed for the credit. I signed it over to me, and then I signed it back to them, right there in one credit app. And then do an NTT and send it and enforce it. And if the president of the bank says, I don't see the payment here, say, well, you can say that, just like that attorney said to me in the hallway. I don't know what happened in that courtroom. I don't know what happened in that courtroom. I've never seen that. And then we went downstairs. They told us to go pick a judge or go down and wait for our judge assignment. We went downstairs, and for about 10 minutes, he just sat there talking to us. And then he started saying things like, and I'm not kidding you, at the time, I was giggling like a schoolgirl. I was just kind of cracking up because this attorney was really lost in the clouds. He came in with a spring and a hop in his step. Oh, hey, nice to meet you. Hey, are you the former homeowner? Oh, no, that's not me. That's my buddy sitting up there at the table. Oh, okay, sorry. Who are you? Oh, I'm just a friend. Oh, okay. And he goes in there, and the court clerk is in there getting ready, and the court reporter just came in, and and then the gavel comes down, all rise. The magistrate comes in, and he says, state your name for the record. And the attorney pipes in, yeah, I'm so-and-so and so-and-so. And then everyone's looking at my buddy. And my buddy, when we came up the elevator, we were told to go to a certain room. So when the elevator doors open, we see the room number right there on the door, and it says Judge's Chambers. Well, for 3 weeks, I've been preparing my buddy for a public hearing, and we weren't prepared to go into Judge's Chambers. And that's the number they told us to go to. But this is after we filed notices and stuff, similar to what you did. So my buddy's looking at me like, am I going into Chambers? And I'm looking at him going, listen, I wasn't ready for this. I don't think you're going into Chambers. This is a hearing. Why are you going into I go, maybe they honored your request. So we had to sit down on a bench right there. You could hear a pin drop in this hallway. There was nobody around, just me and him. And immediately I get out a napkin, like a piece of paper, and I go, listen to me very carefully. I got 10 minutes to train you what to do in there, because I never thought you'd be in there. So I'm like writing stuff down. Okay, this is what your strategy is. You do this, this, and this. You say this, and here's what you don't say. I'm like, repeat after me. And I'm grabbing him because he's like pacing back and forth like he's lost. I'm like, come on, you got to get focused. Repeat after me. So then the court, a bunch of people come up, and we're thinking, oh, maybe it is a hearing. Well, long story short, the court clerk comes out and says, oh, no, you guys are in here. Oh, okay, we are in a hearing. Okay, well, then forget all that stuff. Now my buddy has a piece of paper where the one side is all the stuff I told him to say in Chambers, and the other side of the paper is what I told him to say in public hearing. And now he's just all, he's razzled. And I'm like, come on, you got to get focused. I mean, this is where the rubber meets the road. You got to just put your faith in what I told you to say. That's all you got. Oh, no, by the way, the backstory on that one, if you recall, my buddy he's been living in his house for 3 years without making a payment. He basically didn't have any money. And he tried a bunch of creditor-debtor stuff, and he had some notices in, and finally, 6 months expired, and they foreclosed, and they sold his house, and they showed up with an eviction notice, and he said he wasn't leaving, and the day they showed up with his eviction notice, the mailman came with his treasury check for his OID, which was $500,000. So he's got his $500,000 in his right hand and an eviction notice in his left hand. He doesn't know whether to cry or laugh. And so he calls me up. He says, you won't believe this. And he tells me a story, and I'm just like, wow, the irony. And so he's got this unlawful detainer eviction hearing, and so I said, you know what? You're a perfect case of nothing to lose, everything to gain. I mean, you want to go buy a house and not be vexed with the whole situation. Move out. Call the movers. Spend $5,000 and move. Go buy a house. You could do it right today. He says, no, I really want to see if I really want to stay. I go, right, but this would be different stuff. This is not creditor-debtor. You're going to have to learn it from the start. He's a pretty bright kid. I mean, obviously he got his OID. So he can't be, the worst thing on the planet. But that being said, so we're up there in the hearing, And he's so nervous. I listed 10 things for him to say. And the first thing I mentioned to him 50 times was, be careful how you tell him your name. I mean, and then the court clerk comes out, are you so-and-so? He says, yeah. I'm like, oh, jeez, we're getting off to a bad start here. And then another guy comes out, oh, are you so-and-so? And he goes, yeah. And I'm like shaking my head. And I'm the only guy in the room watching. And it's early, it is quiet in there. And then finally, when the magistrate comes in and says, state your name for the record, he says his name, and then he says, grantor beneficiary. And you can't see this in the court transcript, but I was there. I saw it. I saw the judge's head bow. I saw his head go down, and I heard a gasp come out of the court clerk. I mean, I heard him go, and I saw the judge, and I saw his eyes roll, and all of a sudden I'm thinking to myself, boy, something just happened, because he didn't do that when the attorney mentioned his name. And then the proceeding goes on, and they come to my butt. They talk to the attorney, and the attorney's all happy and confident and talking about, we'll give him another few days to get out. And I think these attorneys. He's like he's done this 100 times. He's not worried. I mean, CW, I sent you a copy of that summons, and I'll quote what you said in your chat session. You said, pack your bags. He's moving out. And I told my buddy, that didn't affect him. He's like, fine, I'll move out, but we're going to go to that hearing. So here we are in the hearing, and all he said was you read that one sentence to the magistrate, and then they ignored him. And my buddy was smart. He just sat there quiet. And they went back to the attorney, and then they came back to him, and he repeated it a second time. Now, I told him this, that if a trust is referenced, it must be treated as a trust. And if you mention it twice, that's a second witness. That's on the record. And you mention it twice, and all of a sudden the magistrate says, well, this one's going to trial. and no one knew what to think. So we get up and leave and go in the hallway, and I looked at my buddy. I said, you did it. You're not getting evicted today. It's a small victory. You don't got your house yet, but you're not getting evicted today. You can call your wife and tell her it's okay. We got through the first hump. And I said, you did horrible in there, but it worked. And he's like, yeah, I just forgot everything to say. And then the attorney comes over, and he's shaking my hand, and he's trying to get my name, and I won't give it to him. And I told him I told you I was Kaiser Sose. And he thought that was funny. And I really wasn't laughing because I was sitting there in amazement that this guy kept asking us what happened in there. Well, 2 days later, my buddy got a registered mail from the law firm. And all it did was repeat what the judge said at one point in there. He said, my buddy asked for an ex parte meeting, an in-camera meeting, and the magistrate. Now, this is just a hearing. This is not a court trial. This is just a hearing. And my buddy said that his rights can't be enforced at law, that there's no adequate remedy, and that he needs an in-camera meeting. And then he mentioned it again, and the magistrate said, well, I don't see any reason for an in-camera meeting. And I'm in the back going, wow, that's exactly what I expected him to say. That's exactly what he does not see a reason. He can't see a reason. He has to say that. So for the record, he says, I don't see a reason. So what does the law firm send 2 days later? We don't see a reason why, And then they go on to tell him how he should get an attorney. You better get an attorney because we're going to trial. Okay, Mr. Law Firm, you got it. Anyway, so here we are. We got this trial coming up in a week or so. We did a bunch of paperwork today, and so tomorrow, and I'll pose the question. First of all, we've never done this before, and this is after 90 days of study, and we're just implementing some basic ideas. And again, it's a situation. My buddy, he can move out any time. He's actually already got his eye on another property because he can. But I said, no, we're going to do this, and he's all in. He says, okay, what are we doing at trial? I said, well, first of all, the plan is we're never going to see trial. I said, the plan is we've got to get some registered mail directly to the judge, and if he calls, we get that in-camera hearing. And I like what you said earlier today. You said if you get that in-camera meeting, that other attorney's going to be there. And we're like, cool. And the head of the law firm is, by the way, my buddy did an NTT on the mortgage company that kicked him out or bought his house. and I'm the senior partner of a law firm. So wouldn't it be nice to have an in-camera meeting and the senior partner of the law firm shows up as a trustee? And you just sit right in camera and say, see, that guy there needs to perform a duty. I need some relief, some injunctive relief here. Temporary injunction. These guys. And then the other question kind of comes in is, what factor or role do you think that OID comes in? Because here's the irony on this thing. His OID was from his mortgage. And it's on his tax return, the name of the company, and I think it's kind of ironic. I'm not even sure it does play a role. Maybe it needs not to play a role, but it's definitely confidential information. And if he wanted to demonstrate he was grantor of that mortgage, I mean, he's got the ipso facto proof, but my comment is, you know what, let's not break that in there, because that could be, I mean, how many judges you think have seen an OID refund on a mortgage like that? Probably not too many. Maybe none. Well, that being said, it's an interesting scenario for him. But here we are. We're putting our thinking caps on. We're going to send. Right now, we're sending a notice of breach of trust to both of them. And once we have the notary proof of the certificate of service of breach of trust, we can admit that, and we'll probably have a non-response. But I figure with the non-response on the breach of trust, which we gave him 72 hours. With the other notary NTT work that we did, which we submitted the SOI NOI to the court clerk to give to the judge. But then when we left, I realized that we can't be guaranteed that the judge would even get it. I said, you know what, we got to go home and send that register. We got to prove we got it, and we can't just give it, go over the counter and say, oh yeah, thanks for giving that to him for us. That ain't gonna happen. So I said, we went home. We got to send him a registered one, and that one goes out tomorrow. But and then I heard you comment that maybe. I guess what is the strategy? And I was thinking, do we want to do a counterclaim, or do we just want to go in as a defendant? And who, by the way, who is the defendant? I suppose my buddy is, obviously, at the trial, but should we just go in and request a hearing as a defendant and go in there and just simply ask for enforcement of relief of a breach of trust, and here it is, and they had 72 hours to produce a chain of signs and 72 hours to produce this and this documentation? I mean, we really need some help here. I think what I saw in that hearing, for as little as he really said, I think I'm trying to give some hope to some people out there. GW's got this stuff. You're splitting it down to science, man. You can put this stuff under a microscope, and it's amazing. But I've heard a couple examples, including ours. You don't have to be a pro here. I mean, yeah, you better understand what you're doing, but I think the biggest thing to understand is what the ruby slippers really are. If you got them, you just got to learn how to click them together. I mean, they're there. I mean, I can tell Harvard people that I know, Ivy League people, about substantive rights, and they're clueless. They have no idea what that stuff is. I mean, people that are lawyers. I got a friend who's on the bar. She's an attorney. She's blind by all this stuff. She swears I'm talking French when I'm talking about a lot of this NTT stuff. I can't even turn her on to it. And she's got problems. I mean, she's going through all kinds of problems. She thinks she's going to solve all this stuff out law. God bless her. She might even do it. But yeah, when you watch the judge's head bow. I told my buddy, listen, my understanding is it'll be me, you, and the judge are the only three people in this whole room that are going to understand what we're saying. And I said, I'm not even sure you understand it. So maybe me and the judge, but especially the judge. And, well, for a small victory that it is, and we have a lot of work to do, I probably have 8 NTT processes going on at once. I got served papers today and another one, but I'm encouraged by what I'm doing for myself personally as far as helping my buddy on such grave circumstances being evicted. Like you said, pack your bags. We're not out of the woods yet. But we're going to go in there guns blazing in terms of, exercising rights. And, I'll keep you posted. So.
Well, still there?
Yeah.
Okay. That's. Don't have any words?
But as far as like I was saying on
what strategy. I don't think it's a counterclaim. I think we're simply going to send the registered mail in and request a meeting and send the pleading. The pleading is trust. And, where do you send them the NOI and the SOI? What?
This is kind of like the show cause hearing without the pleading. It's like you're going directly into a hearing, into that kind of like the shortcut, the fast pace.
It kind of feels that way. It kind of feels like, and what was odd about it is they immediately turned to my buddy and said, "Do you want a jury?" He's like, "No, I don't need a jury." And I'm like, "Good, I'm glad he said that." And then they said, "Well, you can go downstairs and we'll give you a judge." And so when they gave us a judge, I immediately went on my smartphone and looked the guy's name up and found it. Bang. I mean, this guy's got an illustrious career. Oh, I'm like, I'm glad we got this guy. Now I happen to check out a case. He ruled against a big bank. I'm like, yeah, he ruled against a bank, a big one. I'm like, look at that. And then his background is similar to my buddy's. I mean, they almost look like they could be father-son. I was just cracking up at that one. I'm like, it's almost like they handpicked the guy for my buddy. I don't know, but it has a lot of sweet flavor to it. And I mean, I came out of there. We went to lunch, and I can tell you that I have about 5, 6 friends, close friends, all waiting to hear the results of this hearing. They all know my buddy got his OID. They all know, he's trying something new. And they all know that I'm all about NTT. I mean, I can't sleep at night. It seems to be, it just feels right as rain. I'm quoting out of the Matrix, by the way, right as rain. And then, I guess, yeah, it's a shortcut. I mean, the other guy who said he just asked to get in camera, and the judge said, sure, schedule the meeting. And I know a lot of people have been beat up, and the world is harsh out there, and creditor-debtors robbed them, and they're coming in, and it's a re-indoctrination. My buddy, it took me 3 weeks of getting him to forget creditor-debtor. And he would bring, it's all about the language. He's got Black's Law in his office, and he'd always, the language coming out of his mouth, creditor-debtor, I just stop him. I say, that word never comes out of your mouth. We're trust now. We're equity. And I just repeat over and over. We don't use that word. We use this word. He's like, maybe I should do it in promissory note. No, you're not doing a promissory note. We're merging titles. Do you even know what the title is? And I just sit him down, and he got it just enough to get through a hearing. But I'll say this. I feel bad for people that don't give you enough credit for just the simple things that you're trying to teach people. And it's really not that complicated. What's complicated is believing that you actually have ruby slippers, that you've had the power the whole time. And when you use that reference, the 900-pound gorilla, that really entertains my buddy when I tell him that we're bringing the 900-pound gorilla. And he just, now he gets it. Because when you get through a hearing and you walk out in the hallway and the attorney's sitting there, I have no idea what happened in there. I've been doing this for 20-some years. I've never seen that happen. What happened in there? Why are we going to trial? This was an eviction hearing. Why are we going to trial? Hey, I don't really know, to be honest. I just heard this guy on the radio. Oh, no, I got one other funny thing, the guy that I was cracking up. He turned to me and he says, and I quote, "Is this something you guys got off the internet?" And I said, "Well, can you name something that's not on the internet?" It's just one of those funny things. So,
he wasn't laughing, though.
Huh?
He wasn't laughing, though, was he?
No, he really wasn't laughing. He was really bewildered. And then he was turning to me about getting an attorney, and he was always looking at me because my buddy was kind of delirious, and the attorney tried to start recontracting with him, and I put my arm between the two of them, and I said to my buddy, there will be no contracting going on in this basement. And I moved them apart, and the attorney looked at me, and I looked at him, and I go, because we both know we have the unlimited capacity to contract, don't we? And that's when he knew that I was the one pretty much, calling the shots here. And he's looking at me, who are you? Where are you from? And I just wouldn't answer. I was nice and polite, but we were there to get our judge, and we were out of there. And now we got our judge. We got his name. And we're not going to do an NTT on the judge. We don't need to. It sounds to me there's 2,000 years of duty written into this concept of equitable rights. Maybe 1,000 years. Call it 500 years. So it sounds to me like, I don't know if that's a necessary step. I've heard some people, I know there's other people in the group that have indentures given to judges, and I don't know if that's good, bad, or indifferent. Maybe it's necessary. I don't know. It sounds to me like they already have a duty to uphold, equitable rights or equity. I mean, and the only reason I say that is because when the magistrate came in, he was definitely not our trustee. But when you invoke equity and you do it twice, 3 times, and when you reference a trust in court, there was a guy about 3 weeks ago. He said he was actually in an unlawful detainer meeting trying to save his house, but he didn't know enough trust. He had 2 weeks of exposure. That's just not enough. And he went into court and he got blown away, but he did reference a trust. You remember he read his transcript? And you remember he commented that after he said the word trust and he said the word grantor, there was a long pause in court?
Right.
Because he gave away his trust. He had it, and then he lost it.
Yep.
And then he got it back, and then he gave it away. And I was on the edge of my seat when he was reading his transcript thinking, just like I was with my buddy, I'm like, remember I gave my buddy 10, 12 things to say in order, and he only read 2 of them, maybe 2.5. And I'm like looking at him going, say this, say this. Oh, he's asking you to say it now. Say it. And he wouldn't say it. I'm like, oh, gosh, I really didn't know what was going to happen. I mean, I'm giving hope to a lot of people out there. You don't have to be rocket science. And I tell you, looking back, I think it's 10 times more difficult to master the UCC and go into the creditor-debtor arena than it is to sit down and understand your substantive rights. And that's my humble opinion.
Did you get a transcript for the case, that hearing?
Tomorrow, and you know why? Obviously, we established a record in court that he's grantor beneficiary. And that brings me, don't want to forget to mention this other thing, but you mentioned grantor beneficiary in court. It's on the record. Now, the reason why the judge probably rolled his eyes and there was a gasp from the clerk is because he's expressing trust in court, but nobody knows what trust he's expressing. In other words, he can't be construed. The roles, the parties are finite. They're cemented. That's it. There's no construing. So they got to be wondering, who's trustee? Hot potato. And I don't know, but I mean, I'm just saying that obviously it's on the record, so we got to get the transcript because that's going in. It's just more prima facie proof that he's the grantor beneficiary. So, as far as giving you a copy, I have no issues with that. I wouldn't withhold anything from you, the master, the Grand Puma, the Dalai Lama. So I will be happy to provide that if you want to indulge yourself. I certainly wouldn't want to bore you with that stuff either. But the other thing I was going to mention is my own personal matter. It's a mortgage, and I've been Johnny on the spot on time for 8 years. And about the time I had come across your stuff, I had received a letter that a new loan servicer was my new loan servicer. And you know what? That's the 3rd letter in 4 years I've got, because they all go out of business. And I'm going to get a new letter. And I'm thinking to myself, wait a minute. This is a perfect opportunity to challenge their claim. So I challenged their claim. What I did is I sent them a letter that's titled Denial of Beneficial Interest. Notice of Denial of Beneficial Interest. And I claimed myself as the grantor, and I told them, I did a private admin process, and I told them that I know who the beneficiary is, and it's not you. And I'm denying you beneficial interest in my trust. And I got a notary protest, but they went ahead with dinging my credit, and I kept clean hands and up speed on the mortgage till I got the notary protest, and I felt that I had a right to stand on. I decided, hey, I'm going to stop paying them and see where this goes. In the meantime, I also wrote FDIC, because they're the ones who claim they noticed me that a new loan servicer was getting my mortgage. Oh, CW, you'd crack up if you saw this letter. It's short, sweet, and it literally says, we transferred your mortgage to so-and-so. I mean, think about the ramifications that they're construing in that letter. And all I have to do is say, thank you for transferring the legal title. Doesn't that mess them up? In a couple of ways, I think, in my humble opinion. I mean, I don't know anything about this. This just seems common sense to me, that they send me a short, sweet letter noticing me that they transferred. I send them back a letter saying, thank you for transferring the legal title, and get an admin process, notary on that one. And what did I just prove? That I hold the equitable title. Because they try to construe it that they hold equitable, and I just construed it back that they hold legal. And I'm going to win, because I got the protest. And the other implication is, if I can prove to the new loan servicer that they got legal from FDIC by my proof, that screws it up between those two. That opens up a can of worms. Now I have a notary protest proving FDIC transferred legal title. I withhold equitable title. Now that's why I asked you the original question about 45 minutes ago when I said, isn't it at that point where I send a notice of beneficial title transfer that merges the title that I've already proven they hold legal title, and if I convey, I thought you read in Gilbert's Law Summaries, which I own a copy, and I've torn it up. I love that book. And it says you can transfer beneficial interest. But by transferring beneficial interest, you're not transferring the trust res. Trust res stays in place. But by transferring beneficial interest, you're conveying equitable title to merge with their legal title to terminate the trust. Am I not correct on that thinking?
Right.
So if I do a notice,
anytime they're merged in the same entity, terminate the trust.
That's right. So I've got a protest that FDIC transferred legal. I got a loan servicer who just got their NTT the other day. The CEO of the company did. And that one's tight. It seems like every time I do a new one, I get a little bit better at it, and because I have a deeper understanding, or for that matter, a deeper appreciation. So here I am. I'm going to send notice of beneficial title transfer, and that would be my proof to any court that, hey, they had legal title. I just gave them equitable title. It merges. Trust terminates. I just forgave their obligation to me. It's weird to switch roles here, because everyone's getting foreclosed on because they failed to make a payment. They're being construed as trustees. When you've been trying to teach them that, you just flip it around. Now jump in their seat for once. Drive their tractor.
Right.
See how it feels. It feels right. Especially when you got the 900-pound gorilla that you talk about. That's kind of cool. I got a chastised the last time I talked to you because I talk and I don't let you talk. So I'm going to practice silence.
No, that's okay.
Well, I think I asked you 5 questions, but I love going back and revisiting some of your oldest stuff when you're so new, and now you got people that are reporting. To me, 9 months success is incredible. You can't teach people OID inside of 3 years sometimes, So, and by the way, on the subject of OID, I kind of had an epiphany. When you send an indenture to the bank, make sure that indenture includes that when you collapse and terminate debts, that you're acquiring under OID and your A and maybe even your DIV, you're acquiring the interest, the asset interest, and even give them the indenture to say, hey, listen, I don't want to commingle funds. I want you to deposit that asset interest into a irrevocable. Just show good faith. Show them you want to work with the bank. It's just everyday business practice. You're going to extinguish the debt, and you've had that debt there 3 years, so there has to be some OID there. So claim the OID straight from the bank. If you look in Publication 1212, it flat out says in IRS Publication 1212, the bank can pay you your OID directly. You don't have to wait for the IRS to go account for that. Yeah, they can. The bank doesn't have to, but it says right in there it's at their option. But my guess is if you have a nice indenture with the bank, and you show good faith to the bank and you terminate and you show you can merge titles and manage your debt, what's the age of majority? Your legal responsibility? What if you can demonstrate you can merge titles, manage your debt to the bank Don't they want to work with you? They know you're never going to get out of hand. They know you're in a different arena. They like you. Why? So you said it yourself. Every bank has a private side. I believe that to be true. And some banks have bigger private sides than others. And some banks are all private side and very little public. But in reality, I think they all have to have someone that's trained on the private side. That's just a hunch. Even a small community bank. Someone there, and here's what's funny, is I'm doing an NTT on a bank. The president is a classmate of mine. And that's pretty weird because he knows where I came from. So that'll be interesting when he gets that and he calls me up and just say, what is this? I'm saying, listen, I'm merging town, getting rid of that debt, and by the way, I want you to stick the ANOID stuff in a separate account, and I want to pledge the asset in an instrument where I can open up another line of credit, and I'll merge the same title on line credit, extinguish the debt, no one's in any trouble, and then I'm going to just keep doing it. It's called fractionalization. Ever heard of it? Keep fractionalizing one asset on a line of credit, merge the title on the debt, get rid of it, put the asset back in the other on the asset side, and use it to pledge in an instrument to open up a line of credit, do check writing capability on the line of credit. Don't touch that asset money. That's one mistake my buddy, I think, is making. He didn't follow my advice. He doesn't follow all my advice. But, you know, again, I apologize for talking your ear off, but I'm glad I waited 2 hours to get that off my chest.
Well, that's great news. Glad you came on.
Well, I appreciate it. Absolutely, absolutely. And, you know, any modicum of success, I'd be happy to report. Of course, I'm in the room chatting and sharing stuff. You go on Google Books, there's a lot of good stuff in there about non-negotiable instruments. There's not a whole lot you can get on Amazon, but you go on Google Books and look up non-negotiable instruments. There's some good stuff in there. You find out that non-negotiable instruments, and you probably know this, but non-negotiable instruments are assignable.
Yes. Yeah.
And that's what makes it beautiful. It's private and assignable. And it sounds to me like it has all the nuances of an equitable instrument when you call it a non-negotiable instrument. But it's all 1920s, 1918, 1886 type stuff on Google Books. You got to look this stuff up on Harvard Law Review, Yale Law Review. Otherwise, you're not going to see it in modern. I mean, I haven't seen it. You can get negotiable, obviously, all day long, but you know. Well, anyway, I'll sign off, but. Thank you very much. Thank you.
Thank you, Steve.
Thank you genuinely. All right, I'm going to sign off.
Okay, thanks. Appreciate all your hard work. Okay, people, it's past time to go, so today's Monday. We'll see you tomorrow night at 10 o'clock Eastern Time. See you tomorrow night. Have a great evening.